Nevertheless, you took the bait.
Cardio time.
Hey yo, look like I'm going for a swim. Dunked on him, now I'm swinging up the rim. Bitch ain't coming off the bench, while I'm coming off the court fully drenched. Here goes some haterade, get your thirst quenched. Style on him in this Burberry trench. These birds copy every word, every inch. But gang got the hammer and the wrench. I pull up in that $250,000 off the lot. Oh, now she trying to be friends like I forgot. Show off my diamonds like I'm signed by the rock. Ain't pushing out his baby's telly by the rock. Hey yo, I been on, bitch you been con. Bentley tints on, Fendi prints on. I mean I been storm, X-Men been form. He keep on dialing Nikki like the prince on. I been on, bitch you been con. Bentley tints on, Fendi prints on. Hey yo, I been off, Laura been crossed. Play say Chang-Li, drop the Benz off. Oh, I get it. They painted me out to be the bad guy. Well, it's the last time you're gonna see a bad guy do the rap game like me. I went and caught the chopsticks. Put it in my bun just to pop shit.
Say what?
I'm always in the top shit. Box seats, bitch, fuck the gossip.
Right.
How many of them could've did it with finesse?
None.
Now everybody like she really is the best.
Yes.
You played checkers, couldn't beat me playing chess.
Nope.
Now I'm about to turn around and beat my chest. Bitch is King Kong. Yes, this King Kong. Bitch is King Kong. This is King Kong. Chinese ink on. Siamese links on. Call me 2 Chainz. Name go ding dong. Bitch is King Kong. Yes, I'm King Kong. This is King Kong. Yes, Miss King Kong. In my kingdom with my Tim's on. How many championships? What? 6 rings on. They need rappers like me.
They need you
They
to
need rappers
like
like me.
me.
So they can get on their fucking keyboards and make me the guy join them.
Indeed. Oh.
Hey yo, I been on, bitch you been con. Bentley tints on, Fendi prints on. I mean I been storm, X-Men been form. He keep on dialing Nikki like the prince on. I been on, bitch you been con. Bentley tints on, Fendi prints on. Hey yo, I been off, Laura been crossed. Play say Chang-Li, drop the Benz off. Give me the password to the fucking Wi-Fi. Hey yo, I been on, bitch you been con. Bentley tints on, Fendi prints on. I mean I been storm, X-Men been form. He keep on dialing Nikki like the prince on. I been on, bitch you been con. Bentley tints on, Fendi prints on. Hey yo, I been off, Laura been crossed. Play say Chang-Li, drop the Benz. Bitch is King Kong, yes, this King Kong. Bitch is King Kong, this is King Kong. Chinese ink on, Siamese links on. Call me 2 Chainz, name no ding dong. Bitch is King Kong, yes, I'm King Kong. This is King Kong, yes, Miss King Kong. In my kingdom with my Tim's on. How many championships? What? 6 rings on.
6 rings on. What is going on, people? What is going on? Yes, this is part 1. Part 2. What up, Purple? Part 2. It may go down tonight. I may have some guests. So it may go down tonight. You heard me? Did you hear me? So, but what's going on, people? So we got some paperwork. Lord, do we have paperwork, child. I need to get my eyes together. Oh, I get my eyes together. Well, I see everybody is going woo about the what? Jury instructions, right? But we remember how important jury instructions are when I told you back in 2021, right? That jury instruction and the what? Indictment. Okay? The stuff in the middle matters as well, the testimony, the evidence, and all of that. That matters. But if you want to know if the prosecutors proved their case and if the defense raised reasonable doubt or was able to disprove any of those elements, you need to use the indictment and the jury instructions as a guide, right? So I got quite a bit of reading. Hey, Margarita. Hello, honey. So I got quite a bit of reading to do. Ooh. But some of it I might put on that electronic reader. There's a lot going on. Now, but let's get to Mr. Kelly because this is the what? What sector? The R. Kelly sector. And let's get to it. Now, let me make it bigger. Now, let me go back to my post so I can tell you exactly what I said. Somebody done popped up on me. Okay, Cedric, wait a minute. Yes, sir. Cedric, nobody can see you, honey. Lord have mercy. Let me go and ban you. Like, this is ridiculous. I knew to put that overlay up. Cedric, nobody saw your pink situation but me. Okay? Ugh. That's crazy. Okay. So, my post 3 days ago, I said, I don't see how the judge will justify not scheduling R. Kelly latest motion for an oral argument or at least an investigation. What up, Davey? So, Mr. Want to know it all. They're going to deny because it's not in the right jurisdiction, and and la 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 la, right? And I said, well, that's why the attorney rewrote it, right? See, there's a lot of stuff that you will only know if you are who? Wait a minute. Hold on. I don't hear none. I hear crickets. I don't hear you. Wait a minute. Only way you would know is if you are a lawyer. Okay? So, how it was. So remember, I said the attorney went ahead and rewrote it. It went still to the same jurisdiction, but he rewrote it and asking for something that this jurisdiction can comply with if they want to. Okay, but I'll read the order. And this was in response to Bo Brenly's motion for a new trial and a bond, right, pending the outcome of the new trial. All right, here's the order. It says, in 2023, Judge Lennon Weber, who was then presiding in this case, sentenced defendant Robert Sylvester Kelly, better known as R. Kelly, to 240 months of imprisonment, 228 of which was to run concurrently with Kelly's sentence for similar conduct in the Eastern District of New York. The Seventh Circuit affirmed Kelly's conviction and sentence on direct appeal in case law with regards to Kelly. It says, because of the Seventh Circuit opinion recounts the facts of the underlying offense, the court will not repeat them here. On June 10, 2025, Kelly filed an emergency motion for temporary furlough. On June 19th, the court denied that motion, concluding that it lacked jurisdiction. That's why I told Mr. Know-It-All, rocking back and forth, smoke cigarettes and shake ice, that this is why he rewrote it and sent it to the same jurisdiction, asking for something that this jurisdiction could possibly, make an order on, or make a ruling on, or give an opinion, right? Says the next day, Kelly filed a combined motion for a new trial under Rule 33 of the Federal Rules of Criminal Procedure, an emergency motion for bond pending resolution of the motion for a new trial. The court has jurisdiction over Rule 33 motion. Okay? Okay. So what now? Run that back. Wait a minute. Now, since it's been rewritten, he has jurisdiction over Rule 33. Okay? I got this. I don't need no help from the students or anything. I got it from the dependents. I don't need no help. I got it. So they asked for Nasty Angie. So you're going to get that. So then this case law, the Seventh Circuit 1994, noting that district courts have discretion to grant new trials under Rule 33. The next question then is whether the court has authority to order a defendant released on bond pending the disposition of a motion for new trial. As Kelly notes, this court has inherent power to order the release of a prisoner bringing a collateral attack, meaning something like a habeas corpus, meaning that they want to challenge a ruling, but in a new case. That's pretty much the simplest way to explain it to you. But the perfect example would be like a habeas corpus, right? A writ for habeas corpus. Then it gives more case law. It says the cases Kelly cites involve either federal habeas corpus petitions or proceedings under 28 U.S.C. Section 2255. It's more case law. Seventh Circuit of 1985, noting the abundant authority that federal district judges in habeas corpus and Section 2255 proceedings have inherent power to admit applicants to bail pending the decision of their cases. However, the Seventh Circuit has explained in another context that when made following the outcome of a direct appeal, a Rule 33 motion plainly is collateral in the usual sense of that term. There's more case law. Thus, the court assumes, for argument's sake, sometimes arguendo will be asserted there instead of for argument's sake, that it has authority to order a defendant released on bond pending disposition of a Rule 33 motion for a new trial. So what now? It's still out of the wrong jurisdiction. Wait a minute, what you say now? Shake the ice now, what you say now? Light the cigarette, what you say now? Nevertheless, that relief is not warranted in this case. A court's power to order bond pending disposition of a request for collateral relief must be exercised very sparingly. So now he's going to justify why he's denying some of this, okay? Case law says a defendant seeking release pending appeal must, among other things, show by clear and convincing evidence that he is not likely to flee or pose a danger to the safety of any person or the community if released. 18 U.S.C. Section 3143B1A. Although that statute is inapplicable to a convicted defendant who is seeking post-conviction as opposed to appellate relief, the Seventh Circuit has explained that a defendant who cannot bring himself within its terms is not entitled to bail pending decision of his post-conviction motion. Here, Judge Leonard Weber found that Kelly is both a flight risk and a danger to the community. So here's his justification, right? Here's his justification. I mean, apparently he didn't think that the blood clots and he's allegedly being pursued in jail to be killed or anything like that was enough. So let's keep reading. They're saying that him being a flight risk and a danger to the community supersedes that. It says Kelly has not produced any argument or evidence, much less clear and convincing evidence, challenging that finding or indicating that circumstances have changed such that Kelly is no longer a flight risk or a danger to the community. Accordingly, Kelly cannot bring himself within Section 3143B's terms, and thus the Cherrick forecloses release on bond. So I did the homework a little earlier. So that just means that he cannot meet the terms that's set under Section 3143B. Okay, so like he cannot just demonstrate that he's not a flight risk, he's not a danger to the community. And this is just in my opinion. I believe that the judge was kind of looking for something from him in his words, saying like he's taking accountability or he's rehab or something like that. But I told you, that's a kind of sticky situation because he still has a habeas out, out there. He may be having something else that can go to the Supreme Court that he could petition, and and the pardon. Of course, the pardon want to see some type of rehabilitation, accountability, responsibility taken, right? So it's what you do. Okay, where do you go? Says, but even if Kelly could satisfy the requirements of Section 3143B and Cherrick, bond pending disposition of his Rule 33 motion would still be inappropriate because of the significant time remaining on his sentence in the New York case. Yesterday morning, the Supreme Court denied Kelly's petition for a writ of certiorari in that case, rendering that conviction final. So, meaning that, remember, I told you in May, I think May 15th and 19th, one of them, I posted it on the wall. She petitioned for a writ of certiorari. Well, the New York um, circuit has denied that. They denied it actually on the 23rd, and I'll show you that. So they denied it on the 23rd. Ooh, I can't see, child. But yeah, that's on the 23rd of 2025, right there. Okay. So let me see, what was I? Thus, even if he won relief under Rule 33 in this case, he would remain in custody pursuant to his sentence in the New York case. So, I really don't know why they keep sending everything through this Illinois jurisdiction. And I mean, I don't know why they didn't send. They could have sent it um, to New York. Maybe the timely filing has run on that. I'm not sure, but why they're not sending it to New York as well, not sure. Um, that is an independent basis for denying bond in this case. There's more case law. And it says affirming denial of bond pending resolution of Section 2255 petition because, regardless of the outcome of his pending 2255 motion and appeal, significant time remained to be served on the defendant's sentence in another case. Conclusion: Defendant Robert Sylvester Kelly motion for a new trial and bond pending disposition of his motion for a new trial is denied insofar as it seeks bond pending the resolution of the new trial motion. Insofar as the new trial is the motion seeks a new trial, it remains pending. So they haven't made a decision on whether or not he's going to get a new trial or not. I mean, that's probably going to be denied too. But I thought Bo had some exhibits or something that was like, he did he have some exhibits with the new motion he made? Let me see. Baby, you got to show these people something. Yeah, I don't see any attachments. I don't know why they keep running everything through Illinois. Maybe they think that, because I mean, even if you get either way, you still gonna be hell because you have a sentence. I don't know. Maybe we'll see him do something in New York. Now we got did it now. From what I've been told, because I've been following it, both sides of the arrest and the defense didn't call any witnesses. Now, sometimes they do that because, one, they believe that, hey, the prosecutors did not meet its burden, right? Sometimes they do that just because they just don't have nobody to call, okay, that can challenge the dates, that can challenge the witnesses. They don't have any counter information, right? But I'm surprised they didn't at least call some experts to challenge what the experts said in with regards to the prosecutor's case, right? You don't, and also you don't want to call some witnesses that can possibly open the door, for more testimony, they get out and, talk about some other stuff and all that. So, maybe that's the strategy. What up, Karen? Oh yeah, that was with the old that was with the furlough motion. I'm talking about with the new motion for the new trial. Unless he relied on that judge to, you know, to look at that, go back and look at that. But you supposed to attach it again. If that's your evidence, attach it again with the new motion. He attached that on the for the new one. Hold on. What is these YouTube videos? What is this? The truth gonna come out. It's gonna really fuck you up. Hold on. What happened to my damn order? Ooh. You know what? I can't see. Okay. Karen, where you been? We just read that. What up, Pauline? Hey, Pauline. What are these YouTube videos that Bo attached to? The defense has not had time to formally interview Harris because of the immediacy of the information provided. Who is Harris? Ms. Kelly's blood clot began after the BOP mishandled his recovery from surgery to repair his Achilles tendon and failed to return Mr. Kelly to the operating hospital and to remove his leg cast within the time frame ordered by the medical professionals. But wasn't that a couple of years back? While Adams involved in the right of inmates to communicate with counsel, the protection is also less applicable to pretrial detainees. So yeah, so that's that with Mr. Kelly. So right now, I mean, if they want to try to petition to the Supreme Court for some different issues, um, they can always take this denial and try to petition to the Supreme Court based on what they stated in this denial, right? Because there is some alleged um, constitutional violations going on. So you understand, right? Because that's what I was trying to explain. rewrite it and get it in a proper form that it does fall within the jurisdiction and venue, the authority of that particular court, then they can make a ruling on it. But this, in my opinion, this is all to get the attention of who? Donald John Trump. Child, this shit done start popping off again. Hold on. Now, Diddy. I haven't read anything about Red Diddy stuff. So I may put on the white lady and let her read. But they are making, but I kind of want to read it because it's a lot of pages. Let me see something. If you stop it, let me see, does it go back? Does it start over? Hold on, let me see let me see. Where's the shit? Let me see.
Case 1:24 CR 00542 is document 421 filed June 24, 25, page 1 of 12. June 24, 2025. Via email. Honorable Arun Subramanian, United States District Judge, Southern District of New York, 500 Pearl Street, New York, New York 10007. Re. United States v. Combs Incorporated, 24 CR 542, as. Dear Judge Subramanian, we submit this letter in further support of our requested edits to the court's proposed
Now, if I stop it, will it start where it stopped?
Jury charge.
Oh, it
and
does.
To elaborate on some issues referenced in comment bubbles in our requested edits and objections to the government's redline edits. A. California Penal Law Section 137, A. Racketeering Act 3. The defense requests a modification to the proposed charge regarding Racketeering Act 3 bribery in violation of California Penal Law Section 137, A. The requested modification clarifies that a bribe within the meaning of the statute means something offered with the corrupt intent to unlawfully influence the content of the testimony or information of the person to whom the bribe is given. It further clarifies that an attempt to prevent a person from appearing or reporting altogether is not sufficient. Or a law enforcement report will be given, with the perpetrator intending to influence the testimony or report. ID at 362. The government has previously argued that Section 137A is broader in scope. See Governor 13th, 25 Crime Fraud MOT. Reply at 5 to 6. However, the government's arguments misconstrue the statute and relevant precedent. The government cited a California Supreme Court decision from 1982, People v. Pick al. 31 calories 3D 731, 1982, ignoring more recent California appellate court decisions such as People v. Fernandez, which the California Supreme Court favorably cited as recently as last year. See People v. Reneza, 15 calories 5th 982, 2024, discussing Fernandez and citing its observation that the legislature has taken pains to distinguish the various methods of dissuasion in Part I, Title 7, Chapter 6 of the Penal Code, 132 to 140. In fact, People v. Pickell expressed doubt as to the correct interpretation of influence in 137. C 31 calories 3D at 742.5. Its conclusion was premised on its Case 1:24 CR 00542 as document.
Okay, I don't like that. I don't like that. Ugh. I gotta read it. Okay. So I don't need to read that top. It says California Penal Law Section 137A, Racketeering Act 3. The defense requests a modification to the proposed charge regarding Racketeering Act 3, bribery, in violation of California Penal Law Section 137A. The requested modification clarifies that a bribe within the meaning statute means something offered with the corrupt intent to unlawfully influence the remove that. I can't see what that is. The content of the testimony or information of the person to whom the bribe is given, where the person will be given testimony or a report to law enforcement. It further clarifies that an attempt to prevent a person from appearing or reporting altogether is not sufficient. Section 137A punishes attempts to influence the content of testimony given as distinguished from efforts to prevent a victim or a witness from appearing at all. Case law. The statute is narrowly construed to require an understanding that testimony or a law enforcement report will be given with the perpetrators intending to influence the testimony or report. The government has previously argued that Section 137A is broader in scope, which most penal codes are written as broad, right? So it can include a bunch of things, right? Or a lawyer can make it include a bunch of things. It says, see Government 3/1925, crime fraud MOT reply at 5 and 6. However, the government's arguments misconstrued the statute and relevant precedent. The government cited a California Supreme Court decision from 1982, ignoring more recent California appellate court decisions such as case law, which the California Supreme Court favorably cited as recently as last year. Says California 5th 982 2024, discussing Fernandez and citing its observation that the legislator has taken pains to distinguish the various methods of dissuasion in Part 1, Title 7, Chapter 6 of the Penal Code, Sections 132 to 140. In fact, People versus PICL expressed doubt as to the correct interpretation of influence in Section 137. It says its conclusion was premised on interpretation of a separate statute, California Penal Code Section 136 and a half. C 742, which is later repealed in 1987. All right, let me see what else. Because everybody's making a big deal of the government's edits. So let me look through here and see if there's anything that, because a lot of with the defense edits or proposals when it comes to jury instructions, usually a lot of crybaby shit, but it is what it is. Now, it says sex trafficking instructions generally. The defense strenuously objects to the government's proposed additions to the sex trafficking instructions. The government proposed charge regarding counts 2 and 4 tracked the language of the statute and available pattern instructions. The court's current proposed charge will properly and adequately inform the jury of the law. And they give some case law. It says Second Circuit 2014, and it's sufficiently balanced. More case law. The government seeks to undo the court's effort by proposing voluminous, one-sided, argumentative additions to the charge that the fundamentally unbalanced and only point towards how guilt is proved. The government's proposed additions are improper, legally unsupported, and would constitute error if charged to the jury. The court should reject the government's request to inject inaccuracy and imbalance into the charge and to argumentatively inject the government's theory of the case into the charge. Now that's a fair assessment. That's a fair assessment because that would kind of give a one, if they're giving a one-sided version of their story or version of what happened, or the evidence of whatever that particular instruction relates to. It may lead lead the jury to think that, hey, to find him guilty would be only right based on the only thing that we're listening to or we're reading. So that's fine. It says the government cites no presidential authority stating that its proposed one-sided additions to the sex trafficking instructions are legally appropriate or required. Indeed, it cites no authority at all stating as much. The government cited Second Circuit case law does not support any of the proposed additions to the charge. In fact, United States versus Rivera found error in the district court's instruction directing the jury to focus on the particular Jane Doe. If anything, Rivera pointed to Sand's instructions, the instruction that the court and the defense proposed here, as the legally correct instruction. And there's more case law. More citing of a federal jury instruction. So it says that is the instruction the court should give here. In other words, Rivera supplies no authority for any of the government's proposed additions to the sex trafficking charge and only reaffirms reviewed a charge under a plain error standard where the defendant did not object to the erroneous language and the decision merely reaffirmed Rivera and again cited Sand as providing the legally correct instruction. Child, they fighting over these damn instructions. It says, and the United States versus Purcell merely considered the sufficiency of evidence. The decision is simply irrelevant in this context and did not endorse any of the charging language proposed by the government. The United States versus Rainier similarly assessed only the sufficiency of the evidence and did not endorse the government's proposed charging language. In fact, the court observed that the statute defines coercion as well as serious harm and did not suggest that additional gloss on these definitions was appropriate. The government further cites United States versus Marcus, but that decision vacated and remanded a sex trafficking conviction based on an erroneous jury charge. Second Circuit of 2010, further observing that jury instruction stating consensual activities alone could not constitute for the basis of a conviction under the sex trafficking charge was proper. Oh, so look like to me, by them not putting on a case, right? They did not present a case in chief. Maybe they're trying to take care of some of it through these jury charge, right? These edits, you know. More broadly, nothing in these decisions direct courts to marshal the government's evidence or theory of guilt in the charge or identify and elucidate what particular vulnerabilities or means and methods might be at issue, or even endorses such instructions. Hold on, y'all. I gotta use the restroom. I am trying to hold it. 1 second. Sorry, honey. I'm back. And y'all know My greedy behind snuck off to that kitchen. Child. I ran back. Yeah, so well, I slammed this in my mouth and I apologize for eating. But I'm starving. Um, so what y'all think about the Diddy case or the Kelly case? I really believe that I don't know what I saw on that wall. I said he might. It seem like he might get between 10 and 25. Diddy, I'm probably off. But shit, Judge Superman may give him life. I don't know. If he's found guilty at all. I think that the prosecutors, you know, prove their case. I just don't know if the jury understood their case, right? That's what you got to worry about. Did they understand that what they was describing was sex trafficking? And did not help that they had text messages from some of people, like, being down with it, being down with taking the drugs. See, that's where, I don't know. Y'all, I'm telling you, as soon as I learn what to do with that bok choy, it's gonna be some Chinese forever nights. Hold on. I have the worst eating habits. And I think sometimes because I like to take my medicine at night, honey, so it can do the majority of that swelling and stuff while I'm asleep or whatever. Sometimes I try not to eat unless I'm hungry, right? I don't know, be really hungry. Child, sometimes I be getting sick and week. I wish I could find a real have time to do, and I have time. I just don't want to do it. I make them supplement drinks and shakes and stuff, but it got to taste good. It can't taste like medicine, you know. I'm coming. Are they in court today? Are they fighting? What are they doing? Something wrong with my ID, honey. I can't. I don't be seeing what y'all be seeing in Payson. I'm like, am I logged in the right thing? And how about the judge breaking the news to R. Kelly that they done denied his cert? Because it's not in the, from what I saw, it's not in the system yet. I'm like, God dang. You know what I basically think they're saying? The judge is saying that we believe your charges are egregious and we don't want to offer you no kind of relief. Nothing you saying. That's what I really think they're saying. Because he's referring to another district's ruling, right? Or that's why I said I want to, how can he justify it? He justified by saying, hey, another jurisdiction. I mean, even if I gave it to you, but the other jurisdiction is holding you, you know. And sometimes they play that game. Okay, what was I? Now I got a little bit more power. Y'all love me some rice. Okay, what was that? Okay. All right, those are questions reserved for the jury. Questions that need no further instructions beyond what Sand's model charge provides. Tellingly, in addition to Sand's model charge, every available pattern instruction from the circuit court support the court's and the defense initial proposed charge. None endorses any of the language offered by the government. See Fifth Circuit pattern criminal jury instruction X1 modern federal jury instructions criminal 2.68 Sixth Circuit. They're just citing a whole bunch of jury instructions that the judge can reference. That should be a decisive reminder that the government's additional proposed language is legally incorrect and would constitute error if injected into deliberations here. The reason why they keep hollering error That means that if it goes up on appeal, then there could be a standard of review applied that addresses plain error, things of that nature. And with some errors, they will say that the only relief and the only remedy is to overturn the conviction. So, you have plain error, you have clear erroneous errors, so on and so forth. We went over that years ago. The government proposed additions to the charge are erroneous and unsupported for another reason. The majority of the terms used in the sex trafficking statute are statutorily defined. And it says some case law, and it says penalty provision requiring that the offense was effected by means of force, threats of force, fraud, or coercion described in subsection E2. There is simply no reason to depart from the language Congress itself prescribed to govern enforcement of the statute, and particularly no reason to do so without any presidential authority whatsoever. The government further proposes instructing the jury that it's not required that a commercial sex act occur. The proposal is unsupported by any binding authority, is legally incorrect, and conflicts with the indictment. But remember, the indictment and the jury instruction have to coincide, can conflict each other. If you do, it's possible that, hey, upon appeal, the defendant walks, right? I mean, it pretty much means that you convicted someone, you either indicted someone wrongly or you convicted someone wrongly. Because that's why the jury instructions, the indictment, they can have administrative changes, right? Like the and or, that argument always comes up, and or and all that. A word, word here, word there, but nothing that changes the meaning of the fact or the element, or nothing like that. Where was that? Okay, both the language of the statute is penalty. Its penalty provision suggests that a commercial sex act must occur, mean will be used to cause the person to engage in a commercial sex act. 18 U.S.C. Section 1591, A1. Penalty provision requiring that the offense was effected by means of force, threats of force, fraud, or coercion. And the government proposal is inconsistent with the indictment, which charged counts 2 and 4 on the theory that Combs willfully caused the victims to engage in commercial sex acts, knowing and in reckless disregard of the fact that the victims were engaging in commercial sex acts as a result of force, fraud, and coercion. Indictment 1719. The government has separately charged attempt to violate the statute, see 18 U.S.C. Section 1594A, and the court proposes instructing accordingly. That is all is needed. and the court should not suggest in the substantive charge that no commercial sex act is required to convict. Section C, Racketeering Act 6. The court should not charge the jury on 18 U.S.C. Section 1591D because it is unconstitutional as written, and because including a charge on this provision would be constructive amendment of the indictment in violation of the Fifth Amendment grand jury clause. The Section 1591D violates both the First and Fifth Amendment as written. So that's serious, right? If this is all true, okay? Remember, these motions, these briefs, these filings, whatever you want to, whatever it is, are meant to be persuasive, okay? And the Constitution, that's the top. It's mandatory. Mandatory law. The sub-provision criminalizes merely interfering with or preventing the enforcement of the sex trafficking statute in a way. This capacious language, what? Did you mean capricious? It says capacious. Capacious language sweeps in a breathtakingly vast range of completely innocent conduct. Consider, for example, the alleged sex trafficking victim who seeks advice about whether to press charges against her significant other and ultimately decides against doing so, or the close friend of the victim consulted before making that decision. This is not a far-fetched scenario. One of the government's potential witnesses for the trial, Gina Hume, voluntarily decided against testifying or pressing charges against Mr. Combs. Does this really constitute interference with or preventing the enforcement of the sex trafficking statute? Indeed, even if the alleged victim chose not to report an incident because her partner apologized and she decided to stay in the relationship after their discussion, should either of them be subject to punishment up to 25 years incarceration because the government had a different view of the situation? Such breathtakingly broad application of Section 1591D cannot be constitutional. Although true obstruction can, of course, be prosecuted when properly defined to avoid serious constitutional problems, here the government seeks to impose the up and broad. What? Oh, Babe, I don't know whatever it is. Hold on. Oh, approprium. Okay. Approprium. That's the word, honey. Use it, child. Tell you what it means. Harsh criticism or censure. Okay, approprium. Okay. Approprium and stigma of a criminal conviction under an impossibly vague statutory provision for conduct that no person would fairly know to understand to be illegal. This raises serious concerns about one, fair notice, and two, arbitrary and discriminatory prosecutions. Case law, much of it. Says 2019 discussing dangers of vague statutes and holding criminal statute unconstitutionally vague. The Supreme Court has long emphasized the need to provide fair warning to the world in language that the common world will understand of what the law intends to do if a certain line is passed. Okay. And the construed other obstruction statutes narrowly to avoid such problems. I agree with that. Section 1591D, harsh penalties and up to a 25-year prison sentence only heighten these vagueness problems. Case law. The sub-provisions, remarkably broad sweep, may also have a powerful First Amendment chilling effect by causing speakers to remain silent. Reno 521 U.S. at 872, rather than engage in completely innocent and wholly protected speech with their friends, family members, and lawyers. Indeed, some of Section 1591D's potential applications threaten to gut the Sixth Amendment right to counsel, the very foundation for our adversary system. Suppose that an individual, on the advice of his lawyer, decides to exercise his constitutional right against self-incrimination or invoke the attorney-client privilege and refuse to speak with the law enforcement. Read literally, both the lawyer and her client could be charged under Section 1591D for interfering with or preventing the enforcement of the statute. Or what if the lawyer, realizing that her client is the target of a Section 1591 investigation, seeks to avoid charges through negotiations or proper sessions with the prosecutor? How about if the lawyer interviews potential defense witnesses who may help her client at trial, or recommends that an unprecedented witness obtain counsel before speaking to the government, knowing that a good lawyer would recommend that the witness invoke his or her Fifth Amendment right? It takes little work to imagine more examples that would likewise threaten an individual's fundamental right to have the assistance of counsel for his defense. U.S. Constitution Amendment 6. Let me see what else they got, because let me read some of involuntary intoxication. Okay, the involuntary intoxication defense applies to more than just specific intent crimes. Intoxication is a defense to a crime, so long as it negatives a required element of the crime. Okay. Any crime that requires intent, knowledge, or willfulness, accordingly, may be negative by intoxication, which negatives the required mens rea. Remember, mens rea is the what? The mind, right? The mind, the intent, and all of that, right? What you thinking? Lefebvre, what's the Lefebvre, Section 9.5a, even if the crime is not a specific intent crime. In particular, if intoxication does in fact negative an intention, which is a required element of the crime, whether it be called specific intent or general intent, right? Specific intent, that meaning you plan to do it, right? General intent, you did something knowing that the consequences could be, death or something. The crime has not been committed. In United States versus O'Day, for example, the Sixth Circuit vacated a conviction and remanded because the district court erroneously excluded PTSD related evidence and held that the crime need not require specific intent for such evidence to be relevant. Regardless of whether the crime was one of specific or general intent, the court explained the proper testimony was relevant to whether the defendant had the required mental state and was potentially exculpatory because it undermined an element of the crime. Wow. Let me see. All right, let me read this. Although the Second Circuit has indicated, albeit in the narrow context of the federal bank robbery statute, that voluntary intoxication may be limited to specific intent crimes, case law, it has nonetheless affirmed the grant of a new trial based on the failure to instruct the jury on voluntary intoxication as to crimes such as attempted sexual abuse and attempted aggravated sexual abuse. Moreover, the Second Circuit has held that intoxication evidence is admissible for the purpose of rebutting the prosecution proof of mens rea and for the purpose of negating the intent element of a crime. Case law. In any case, the intoxication evidence is highly relevant to this case, even under this narrow definition of the defense, because many of the alleged crimes are specific intent crimes. Hold on. Is that the truth? Let me see. Okay. Sex trafficking, kidnapping. Oh, it is. Oh, it is. So they want to use pretty much you. They were willing participants. They want to, get intoxicated. They want to take the drugs. Attempt under specific attempt. Kidnapping, bribery, witness tampering, forced labor, Mann Act, possession with intent to distribute of them drugs. That's all up on that RICO. So the defense requires a modification to the court's proposed instruction concerning 18 U.S.C. Section 1589A mens rea requirement. Forced labor requires knowledge, and with respect to 1589A, the defendant must engage in prohibited conduct knowingly in order to obtain the victim's labor or service specifically. In other words, the defendant must have intended to cause the victim to believe that if she stopped working for him, she would suffer the sort of serious harm that would compel someone in her circumstances to keep working to avoid that harm. It is not enough that the defendant merely obtained or provided the labor or services of another individual while knowingly using force or serious threats of harm. I don't know about that one. Let me see. Okay. Now they're talking about, let me see if we want to read this. Okay, remember, through these elements, they're talking about specific intent. So you got it's mens rea, actus rea, concurrence, meaning the actus reas and the mens rea happen simultaneously. And you have what? Causation. Remember, I used to tell you about causation a long time ago. And the test for causation is but for. Like, but for me hitting you in the back of your car, you wouldn't have suffered whiplash. Okay? So it says immunize witness instruction, right? These are people who have received immunity. The defense requests a modification to the court's proposed immunized witness instruction. The defense requested instructions is both recommended by Sand and consistent with binding Second Circuit precedent. Testimony of certain types of witnesses may be suspect and should therefore be scrutinized and weighed with care, such as those who have been granted immunity. Immunized witnesses receive a benefit for their testimony, and their testimony may be colored. So it is appropriate to instruct the jury to view such testimony with caution and great care. Oh. So let's go to the drug predicate instructions. The defense have several proposals for an objection to the instructions for Predicate Racketeering Act 8, which alleges both the substantive offense of 21 U.S.C. Section 841A1 and conspiracy to commit that offense under Section 846. Mr. Combs proposes adding standard language clarifying that possession for mere personal use does not violate Section 841A1. This proposal is both recommended by SAN, Modern Federal Jury Instructions, Criminal 56.01, 56-11, and consistent with binding case law. Mr. Combs requests an instruction that draws this bright line for the jury in a case where failure to do so could easily lead it astray. The jury must be on notice that the ample evidence of the personal use of narcotics, in this case by both Mr. Combs and others around him, does not prove the charged predicate act. And Sand explained, the jury must determine whether the drugs in the defendant's possession were for his personal use or was for the purpose of distribution. Uh-oh. Ooh, that's a good question, y'all. That's a good one. Without Mr. Cohn's proposed language, the jury won't even know it needs to make this choice. Ooh! Give me a drink. Ginger ale, honey. You can't argue with that. They got a lot. Okay, let's read this by conspiracy. The court should reject the government's request to instruct the jury on conspiracy to violate Section 841A1. The court was wisely decided against instructing the jury on conspiracy offenses for the Jury Predicate Acts. It should do the same for Predicate Act 8, for which there is no legal factual support for a conspiracy theory. Such an instruction would also be highly confusing to the jury, not just because of the general conceptual difficulty of comprehending a conspiracy to conspire in the context of an 18 U.S.C. Section 1962D charge, but also because this is the only predicate for which they would be instructed on a conspiracy theory. The court should adhere to its prior position declining to instruct on conspiracy predicates and reject the government late breaking request to tack on a new theory to its otherwise deficient Section 841A1 predicate. Mhm. The defense further requests that the court gives the following additional instruction on implicit bias added to the improper consideration portion of this charge. It says the defendant and the government are both entitled to a trial free from prejudice, and our judicial system cannot work unless you reach your verdict through a fair and impartial consideration of the evidence. I'm going to ask you to you and advise you to not decide the case based on implicit biases. Everyone, including me, has feelings or assumptions or perceptions or fears or even stereotypes, and their reference referred to as implicit biases, and you may not even be aware of them. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making a very important decision in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to any conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. Mm, mm, ooh. All right, this is a government song everybody flipping out about. Hold on, let's see where we at. What up, Mo? Well, with the judge, you never know how he's going to decide. Mo, are they still in court or what are they doing? Mm, I'm gonna start reading, y'all. I'm sleeping. I can't stand this day stuff. This is for the birds, literally. Okay. The government respectfully writes regarding its requested edits to the court proposed jury instructions. The government understands the court's desire toward streamlined instructions. With that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed instructions from the charge relating to one, attempted kidnapping under both California and New York law, two, attempted arson under California law, and three, aiding and abetting sex trafficking. What? The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. Huh? Oh, let me go get the indictment. Let me find the indictment. What? Now, what they said they're not proceeding on? You said you're not proceeding on attempted kidnapping. I think these are all under the RICO. Well, I can't see this writing. Kidnapping, arson, aiding and abetting sex trafficking. Is that L? Ooh. So that's all under the RICO. So they're taking out three on the RICO. One, two, three. And so what they gonna leave you with? Hold on, you got one, two, three, four, five, six, seven, eight. Taking out three again, so that's gonna leave you five. So you'll still make your two. Mm, 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 mm. The government also has attempted to simplify the language relating to count one, a proposal as explained in the government comment bubbles that the government hopes not only serves as purpose of streamlining the instructions, but also will avoid any confusion as to the operative agreement for count one. Sex trafficking and forced labor instructions. While the government has taken seriously count court's desires for brevity, brevity, the government still strongly believes that I can't see. Listen. the government still strongly believes that certain limited additional instructions on sex trafficking and forced labor instructions, which are regularly given in sex trafficking and forced labor trials in this circuit, are necessary for the jury to adequately understand the law on these charges. Each of these instructions reflect established case law and are directly relevant to key issues in the case. Moreover, without such instructions, the government has serious concerns that the jury may misunderstand the applicable law for both charges, which are extremely complex legal concepts about which jurors may have preconceived mistaken notions. The government has listed the precedent for each of these instructions in its comments to the forced labor and sex trafficking sections of the requested charge. To avoid repeating that law and precedent here, the government limits the below largely to providing the government's reasons why, based on the particular facts and issues in this trial, these additional instructions are necessary. Sex trafficking, forced labor, requested instruction 1. Due to the particular facts in this case, the government believes that it is imperative that the court inform the jury that prior consensual sex activity is not determinative of whether a victim was sex trafficked. Uh-huh. Ooh, I don't know if y'all gonna be able to get that in. Because y'all get that in, he gonna get convicted. Because that's going to counter that consent and some of that stuff that the defense want in their edits. As this court is well aware, the facts of this case involve instances of trafficking of Jane and Miss Ventura that follow instances of consensual sexual activity, a topic that is likely to be discussed extensively by both parties during closing. And it is Second Circuit law that earlier periods of consensual activity do not preclude a finding of trafficking as to later activity involving a victim. And they cite Ranieri. Recognizing that sex trafficking encompasses acts that compel a person to perform or continue performing commercial sexual activity. Mhm. The fact that Jody's enslavement arose from her initial participation in consensual BDSM activities does not require a contrary conclusion. And also, right, was it sex trafficking? That's what we're talking about. So you can have a willing participant, right? You can have people that, hey, sign up to be in sex trafficking, right? Hold on, let me look at something before I say that. Hold on. I'm coming. I look at something. Okay, that's what I thought. Okay, I was right. Oh, okay. I thought I was right. Okay. You can, sign up and be in a sex worker and be in, but what makes you traffic it is like the ring, somebody setting up the ring and you're paying for services and you're going across state lines and it makes it federal and all of that. So somebody can voluntarily say, yeah, I want to make some money being in your sex traffic ring. It's still illegal. Right. So meaning like I don't know how the government is going to pull that up because they may not the jury may not understand what sex trafficking is. They may just believe that that's something people are doing by force against their will. It can either be consensual or against your will. It's just the other activity, the what the other the elements of that crime is. Okay. Um, what was that? Okay. The same is true for forced labor. The government forced labor theory focuses on four victims, Cassie, Jane, and Jane, with regards to their participation in freak-offs or hotel nights, and Mia and Capricorn Clark, with regards to their employment for the defendant. Similarly to sex trafficking, Cassie and Jane's prior consensual sexual activities do not preclude a finding that later non consensual sexual acts are forced labor. Oh, okay, that's what they're trying to do. Well, you're trying to get the same act for forced labor and sex trafficking. Okay, okay. This is finding that later. All right. It says victims' initial willingness to perform certain labor does not preclude the possibility that the victim's continued labor may become forced, nor does the fact that Mia and Capricorn willingly took jobs with the defendant preclude a finding that both at some point were forced to work. To avoid any confusion on these points, and to ensure that the jury applies the correct law to the facts of this case, the government respectfully requests that the court include such an instruction. Mm. The requested instruction number 2, payment not determinative. The government respectfully requests that the court instruct the jury that sex trafficking labor and payment to the victim for that conduct are not mutually exclusive. For sex trafficking, this instruction is crucial because of the fact pattern underlying Jane's trafficking by the defendant. As Jane testified around April 2023, the defendant and Jane entered into a multi-year love contract under which the defendant agreed to pay Jane's rent in the amount of 10 grand each month. While that contract was in effect, and in part as a result of terms of that contract, the government alleges that Jane was trafficked. Because jurors may be under the mistaken impression that someone cannot be coerced if they receive compensation in return, the government requests that the jury be instructed as to the law that payment alone does not preclude finding a finding of guilt as to sex trafficking. The payment alone does not affirming convictions despite victim statements, and that the defendant paid them and they earn more money with the defendant than they would at their next best employment option. But I don't know how y'all gonna pull all this off. Because the forced labor victims also receive money or gifts from the defendant, it is important to instruct the jury that payment does not preclude finding of forced labor in order to prevent confusion. As noted above, the defendant paid Jane $10,000 per month rent and similarly paid for Cassie's rent and other expenses. In addition, as employees, Mia and Capricorn was paid salaries by the defendant's company. The jury may not intuitively understand that this payment does not preclude a guilty finding of forced labor. I don't know, government. I don't know about all this. It looked like to me you said you started out telling me you're gonna streamline it. Seems like you're making it a little bit more complicated. Oh, I'm think y'all worried that y'all ain't make y'all cakes. This is a lot of edits. God damn. There's a lot of edits, right? No. Let me see if it's worth reading. But right here it's talking about, says the government proposed additional charge language instructing the defendant that they may consider a defendant's cumulative conduct is particularly necessary in this case for a jury to understand what it can consider in assessing whether Ms. Ventura was coerced. Throughout the trial, the government has introduced evidence that not only of threats and harms directed at Ms. Ventura over a multi-year period by the defendant, but also the defendant's threats and abuse of others of which Ms. Ventura was aware. Under the law, the jury may consider all of this conduct in assessing whether a victim was coerced. Y'all kind of stretching it. Viewing the defendant's cumulative conduct and holding that government had to meet its burden of proving coercion. When evaluating if a defendant exerted coercive control force over a complainant, juries are thus directed to evaluate the totality of a defendant's conduct toward trafficking victims, including any threats of specific instances of past violence that may have created a culture of fear, such that the victim's conduct was rendered involuntarily. However, without such an instruction, jurors may mistakenly believe that they are confined to considering a narrower category of evidence in deciding whether the elements of sex trafficking are met. The cumulative conduct in forced labor instruction is also important for Mir and Capricorn. Both worked for the defendant over long periods of time, and during their employment, the defendant was violent and threatened them. The cumulative effect of the violence and threats can all be considered by the jury in assessing whether either was forced to engage in labor or services for the defendant. Without the instruction of the nature, jurors may feel they are constrained to consider only whether a particular act of violence or threat resulted in forced labor. Hmm. Question instruction 4, physical restraint. Based on the cross-examination of Jane and Mia, the government respectfully requests that the court briefly instruct the jury that physical restraint is not required to establish sex trafficking and forced labor. Okay, hold on. Okay, either they realize they done erred in their case, or they don't think the jury understand anything, which means that they didn't lay this case out correctly. Hold on, hold on. Because you're not going to have me up here reading all your mistakes all day. We're not going to do that. If anybody wanted to email me, because I'm not going to keep doing this. Hold on. Based on request that the court be restrained, physical restraint is not okay. Okay, section. Let's move to this one. The government respectfully requests that the court add a single sentence to its charge on sex trafficking to clarify that the defendant need not be the person who received the thing of value from the sex act. The government believes that this short instruction is necessary here due to the particular relationship between the parties and the potential that the jurors will be influenced by preconceived misconceptions about trafficking that do not comport with the law as it will be explained to them. And then they, Noble versus Weinstein. Congress noted that trafficking in persons is not limited to the sex industry. Right. A short instruction on this point is needed to clarify the proper scope of the statute. Huh? Okay. Let's read a little bit of this one. Like, god damn. Requested instruction 6, commercial sex act need not occur. The government respectfully requests that the court adds a very short instruction reflecting the black letter law proposition that a completed commercial sex act is not required for a sex trafficking conviction. Without such a charge, a juror may incorrectly think that a commercial sex act must occur for a sex trafficking conviction. The phrase would be used to cause from the statute is not readily understandable for non lawyers and may be misunderstood by the jury as requiring a commercial sex act result. Second, this law is relevant to the facts of this case. For example, as your honor is aware, one of the specific instances of alleged sex trafficking which the government has focused on during its case is the incident at the Intercontinental Hotel. The government has presented evidence that the defendant kicked and then dragged Miss Ventura in the direction of a hotel room where an escort was standing by and a freak-off had been in progress. A juror could reasonably find that even though a commercial sex act did not occur immediately after the defendant attempted to drag Miss Ventura back to the room, the elements of this count were otherwise met at that time. Woo! Reckless disregard. The government respectfully requests a more detailed reckless disregard instruction. The government anticipates that one of the key disputes as to count 2 and 4 will be whether the defendant had the requisite knowledge that Jane and Miss Ventura felt forced into engaging in these sexual commercial acts. While knowledge, a term people use in their everyday lives, is likely to be readily understandable to the jury, the government believes that an additional explanation is needed to explain term reckless disregard to the jury, a concept with which non-lawyers are unlikely to have ever encountered. Conspiracy instruction. The government proposal also requests certain additional language outlining the law on conspiracy. The current definition is only a few sentences long. The government is concerned that it may leave open too many unanswered questions for jurors, which would result in a number of jury notes seeking clarification. It is imperative that the jury understands the law of conspiracy, a legal concept that is not intuitive, in order for them to correctly apply the law to the facts relevant to count 1 as well as to the narcotics conspiracy predicate. The government has carefully gone through conspiracy instructions that are regularly given in this circuit and has only proposed adding that language that is directly relevant to issues in this case. The government is available at the conference to answer any questions the court has about why such instructions are necessary for the jury's understanding this case. Effect on interstate foreign commerce. The government respectfully requests that the court add a short instruction in its discussion of the interstate commerce element of the racketeering conspiracy that narcotics activity has an effect on interstate commerce as a matter of law. Indeed, the Second Circuit has found that narcotics activity satisfies the interstate commerce requirement for a racketeering enterprise. Of course, special importance to present case, we have held that because narcotics trafficking represents a type of activity that Congress recently found substantially affected interstate commerce, the actual effect that each drug conspiracy has on interstate commerce constitutionally irrelevant. It follows that where whereas here the RICO enterprise business is narcotics trafficking. That enterprise must be viewed as substantially affecting interstate commerce, even if individual predicate acts occur solely within a state. Child, wait a minute. Let me look up this statute. Wait a minute now. It follows whereas here the RICO enterprise business, narcotics trafficking, that enterprise must be viewed as substantially affecting interstate commerce, even if individual predicate acts occur solely within the state. Oh, that's going to be confusing. Context noted. We have held that where the racketeering enterprises business is, you know what to help them? If you go get R. Kelly's jury instruction and use that, because this is ridiculous. This is absolutely ridiculous. In your closing, honey, you're going to have to use the my tree method, honey, to tie this all together. Because you have, they got to understand that, that sex act can be for both sex trafficking as well as the forced labor. They got to understand all of that, sweetie. This is a lot. Mm-mm. Oh, Lord, they got the venue. The government respectfully requests that the court modify the instruction currently included in the discussion of venue, that ministerial functions and preparatory acts occurring in the district are insufficient to establish venue. The circuit has held that venue may be satisfied for sex trafficking where a defendant contacts a victim who is located in the district for purposes of enticing them to engage in sex trafficking. Uh, was the Second Circuit 2020. Finding venue satisfied where a minor testified that Benjamin first contacted her using Facebook Messenger in the fall of 2015 when she was living in a residential treatment center located in the Southern District of New York for purposes of enticing the minor to engage in prostitution. Since the conduct in Walsh may erroneously be construed by a juror is merely preparatory. The government requests that the court modify this portion of the venue instruction to reflect the language in the United States versus Beech Nut Nutrition, Second Circuit 1989, by clarifying that acts such as preparatory to the offense and not part of the offense are insufficient to establish venue. Whether the crime being continuing or non-continuing, venue is not proper in a district in which the only acts performed by the defendant were preparatory to the offense and not part of the offense. However, the inclusion of the term ministerial functions may further confuse the jury and in any event does not appear to be relevant to the conduct in this case, nor is the government aware of any circuit precedent for that portion of the instruction. Accordingly, the government requests that the reference to ministerial functions be omitted. Hold on. So they just pretty much saying, um, hold on, let me make sure. Okay, so pretty much if you contact somebody in Florida and you live in Georgia, they'll tell them for the purposes of their venue that could be established for sex trafficking. Okay, unanimity. The government objects to the unanimity instructions for the sex trafficking and Mann Act offenses. When the Mann Act was in there, he got charged with Mann Act. Hold on, hold on. Are you know what I said? Are you calling in the? Hold on, y'all. I gotta use the restroom again. Hey, Serene. You go once I get my hands on you. Dum, dum. Ooh, boy, I love you. Okay, what was I with the unanimity? Okay. That's unanimity instructions for sex trafficking and man act offenses. The government has been unable to find a single first sex trafficking man act case where unanimity instruction was given and were concerned and are concerned that the language as drafted will introduce error into the charge. Accordingly, the government purposes the following language, which is designed to reduce the risk of error and confusion. The intent of these edits, among other things, is to properly characterize what constitutes the relevant instance and to make clear that unanimity is only needed for elements, not means. Oh, that's my child. Affirming instructions to the jury that to convict it did not it did not need to conclude that unanimously as to how Corley violated 18 U.S.C. Section 1951A, specifically whether he either harbored or to participated in venture that harbored minor victims, because harboring and participating in ventures to harbor are alternative means of committing the offense. Quoting that 10 different acts in which a person may engage to commit the offense of sex trafficking of a minor, in particular recruits, entices, harbors, transports, provides, obtains, advertises, maintains, patronizes, or solicits by any means, are means and not elements. Okay. Ninth Circuit 2008, force, fraud, and coercion are alternative means of violating Section 1951A, right? And to do and so do not need to be found unanimously. That in cases that fraud, force, or coercion are means of accompanying sex trafficking and not elements. Oh Lord. Count 2 and 4 proposed instruction. The government has argued that the defendant committed sex trafficking with respect to Cassandra Ventura and count 2 or Jane for count 4 over a year-long period. To find the defendant guilty, these counts she must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of sex trafficking within that period. As to that specific instance of sex trafficking, you must agree that all the elements were met beyond a reasonable doubt, but you need not agree as long you but you need not agree to the way in which the elements are satisfied or all that details the instance. This is what they are proposed to go into the jury instructions. That's what I'm reading. Count 3 and 5 proposed instructions. The government has argued that the defendant violated federal laws regarding transportation to engage in prostitution with respect to Cassandra Ventura, among others, for count 3, and with respect to Jane, among others, for count 5, over a years-long period. To find the defendant guilty on these counts, you must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of transportation to engage in prostitution within that period. As to that specific instance of transportation to engage in prostitution, you must agree that all elements were met beyond a reasonable doubt, but you need not agree as to the way in which the elements were satisfied or all the details of the instance. To the extent that the government court has questions about certain of these proposed edits, the government is available to answer these questions at tomorrow's conference. Oh, girl. Child, they done gave me a damn headache. Do y'all have a headache? Because I do. But judge. All right, here go the verdict sheet. Count one. How do you find the defendant? Not guilty or guilty? If you answer not guilty as to count one, proceed to count two. If you answer guilty, which racketeering act do you? Oh, I can't see that. Wait a minute. Okay, do you unanimously find the defendant agreed would be committed? Count two, sex trafficking to Sandra Ventura. How do you find the defendant? Count three, Cassie. Man act, transportation. Count four, Jane. Count five, Jane Man act. Okay, so they came out with, I guess, a better one. A better verdict sheet. Verdict sheet. Please indicate each of your verdicts with a check mark. Racketeering conspiracy. How do you find the defendant Sean Combs with respect to count one? Guilty or not guilty? If you found the defendant guilty of count one, then please indicate which pattern of racketeering activity the defendant agreed which would be committed involving kidnapping, including attempting kidnapping, aiding. What? Why don't y'all do it like R. Kelly's on Honey, where he listed every racketeering act separate and you check which one, baby. Oh, this gonna be a mess. This is to be a mess. So instead of like breaking it out, where you say kidnapping, proven or not, aiding and abetting, proven or not. Remember how R. Kelly's on was? They just repeated like they got a. They want them to circle which one, I guess, for each one of them. What? No, they changed the language. Okay, they changed the language. I'm sorry. My bad, my bad. They changed the language. Okay, they changed the language. The first one, I got confused. The first one is California law with the aid and abetting. The second one is New York aid and abetting. The third one is aid and abetting arson, the California law. The fourth one is aid and abet and bribery, California law. The next one is um, tampering with a witness, federal law. Forced labor, federal law. And okay, so they did break it out. Okay, they did break it out. It's just the languages. Okay, they did break it out. But I thought they said they was taking out. Wait a minute. I thought they said it was taking out kidnapping, both California and New York, arson, California, and aid and abetting. Okay, they are. Okay, they are. This verdict sheet, I guess we're gonna get another one. It came out before the edits. Okay. I guess we're gonna get another sheet. Ooh, child, honey. That done wore me out. That done wore me all the way out. What y'all think? Mm, 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 mm. That done wore me out, child. I'm supposed to do another live tonight. That's a lot. Have y'all been following the little case about the dude that killed the wife and they got the herpes and the witchcraft that I've been sharing on that wall? I just can't stop following that story. When I talk about ghetto and Negroes and all of that, them the ones I be talking about, people like that. I don't, Baby, I be like, I can't roll with you. I can't deal with you. Oh my gosh, baby, that hood, I can't do the hood, y'all. Sorry. When I was in the hood, I wasn't hood. Those people act like pure D savages. You hear me? Savages. I'm not interested in that type of life. They saying all kind of stuff. I'm like, Lord have mercy. Yeah, I'm like, man, that was a lot. I mean, the judge said a new trial is pending, but I don't know. He could probably deny that too. These people just deny. Mo.
Hello, how are you?
I'm fine, honey. How are you?
I am doing okay. I've been listening in the background. I've been so busy and I haven't listened to everything because I've been in and out. But this Diddy situation, I want to know if I had a reading comprehension issue and you helped out because as I was listening to some of what you were saying, I was like, you know what? When I was reading, what people were saying, like, oh, all the charges got dropped and so many charges got dropped. And then I'm reading what they, were saying, and then some other channels were reading the rest. And I'm like, I'm not hearing that that's the case. To me, it was just overt acts that essentially they're saying, hey, we're not going to bother trying to defend that. And then providing clarity for
Mm-hmm.
those. But, even Harvey Levin, and wasn't he an attorney? I thought that he was an attorney
Yeah,
before he became the TMZ guy
yeah,
because I remember him from the People's Court. He was one of the main people who came out and said, "Oh, all these charges are getting dropped," and what
right.
have you.
And
Where are people getting that from?
I shared that video, and he pulled it.
Oh, did he pull it?
Uh-huh.
Yeah, because it's
I said it was
inaccurate.
wrong. It's inaccurate.
It's very inaccurate, and I don't have a law degree, but everything that
Mm-hmm.
I just general reading comprehension, I was like, that's not what they're saying. They're saying
Right.
that there were, and we know those were never charges anyway. Those were overt acts,
Yeah.
and pretty much they're saying, hey, let's take the confusion and all the the unusual stuff off the table, if you will. We don't even, and quite frankly, and I know some people are saying, oh, this is the prosecution is desperate, and I feel like it could be a desperation thing, but I also think it could be a thing of confidence of, hey, we don't even need that. We don't even need to put anything on the table that's going to create a whole lot of debate. Take the junk off there and leave the stuff on there, and we still have more than what we need in order to convict. Why bother to, go round and round about it, is how I read it. But as an attorney, what I may have missed that part. What's your read on it? Or do you think it
When
doesn't actually insinuate either way?
when I read it all together, um,
Mm-hmm.
because they asking to simplify a lot of things.
Mm-hmm.
Judge, can you put this edit in? Can you put that edit in? Whatever. I believe that. I mean, they may have some concern about their case. Um, that they may believe that the jury may be confused, may just see this
Mm-hmm.
as a man who has some adults who consented. They have
Mm-hmm.
evidence where some of these women, like, yeah, let's do the freak offs or whatever. Um, that may con that may confuse them, right?
Mm-hmm.
And what they should do is just go get that R. Kelly jury instruction,
Yep. And copy and paste.
copy and paste, baby, and that gets right to the point, and
Uh-huh.
that pretty much lays out the language of, because the judge is going to, and from the jury charge, he's going to read that jury charge to them,
Yeah.
and they are expected to understand the law as it's given to them,
Mm-hmm.
right?
Mm-hmm.
So, they may not understand that, although, even if a person volunteer to be sex trafficked, or if they don't volunteer to be sex trafficked, it's still a violation of penal code such and
Yes.
such. So
Yes.
that it means that, I'm just saying that he's guilty of that charge. They may not
Mm-hmm.
understand that. So,
Mm-hmm. And we see that, right?
mhm,
That's our saga that we've had for the past 5 years.
yeah,
You know what I'm
exactly,
saying? I'm trying to
exactly.
help people, one, understand consent is not something that lasts in or stands in perpetuity.
Yeah.
making sure that people, just making sure people understand that certain things you cannot consent to legally. Period. Even like the whole argument that is, especially in our community, they wanted it, they liked it, they agreed to it, this sort of
Yeah.
stuff. I don't understand why. And quite frankly, it feels like more middle age and up adults have that idea than it is the younger generation. And that maybe it's because we educated them a little bit better on consent, but like people just do not know how to wrap their heads around consent. And
Right.
it's still deeply rooted in our culture and in our communities that if you agree to it, then the law doesn't stand. The law does not recognize any of these gross misinterpretations. And I will be one to go on the record and say, and I agree with it, because I do not think that people should. Well, I won't say 100%. You don't know. I don't go 100%. I don't learn something from Angie over the years. I ain't gonna do no absolutes. But people, if we know that something is this detrimental and harmful,
Right.
to sit up there and just use the excuse of, oh well, you agreed to it, and if nothing else, people almost use it as if it's some sort of standing verbal contract that you also can't void it. It's irrevocable. It's irrevocable consent in a lot of people's minds, which makes me very worried about what's going on in a lot of bedrooms and lives
Right.
around the
Right.
world.
What is
Because
going on?
and at the same time, those same people know it would be like, it doesn't apply. Oh, something else. Oh no, it doesn't apply like that for that. But when you're talking about something as close and personal as substance abuse and intimate interaction, all of that stuff, they're like, oh no, if you consent to it one time, all bets are off. You now have no control or autonomy over your body whatsoever. And that means that they're just trying to take down a black man. And it's the number of people who go, oh, you don't even know what RICO is. And I'm like, well, you don't know what RICO conspiracy is, and you don't know what RICO is.
Right.
There's a lot
Exactly.
there.
And but my cringe worthy is when they say, "Oh my God, well, he's taking care of her. Well, he paid her
Who
rent."
cares?
Oh gosh, I mean, as money, that means that it's a lifelong contract. What?
The
Like,
patriarchy of it all, it still comes back from the days where especially women and children, but in this case women, were owned by the male. And a lot of
yeah,
people still have that, whether they acknowledge it or not. That's still a part of that reasoning as to why you feel that way. If I pay for it, Mister from from Color Purple, that's how it is. I pay for
yeah,
it, whatever, so I can do anything I want to do with you. I can climb on top, I can hit you, I can knock you around, whatever. You're eating, aren't you? You got a house over your head. That is that,
mm,
and that is the core of coercion. That is the core of manipulation as well. You should not, if you're in a relationship with someone, you should not be doing those things as a transaction that then gives you rights to do anything and everything that you want to that person because you're giving them a lavish lifestyle or any kind of lifestyle. You should not be buying control over people. And people don't understand as well. When you're saying that, you're literally describing human trafficking. That is human trafficking.
exactly, right,
You're
exactly.
actually
Oh my
substantiating
God,
the claim. You're not fighting against it. You're substantiating it by saying that there is a price tag with which we can then control and own and manage people and decide what they can do and cannot do. That's human trafficking. That doesn't work.
right. That is, I mean, that is such an ignorant view of a modern day woman. I don't get it. Well, it just, I'd be like, I just throw my hands up. Every time I hear it, I'd be like, oh, la, 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 la. I don't want to
Yeah.
hear that
Get
because,
out of here.
right, um, it doesn't help that the statutes are written so broad, but I
Mm-hmm.
understand why they write them broad. And then when the trial is coming to a completion, this is what you get, all of these edits. But this is a lot of edits on
It's
both
pretty
sides.
substantial. And I will say, I don't blame people for being caught off because I found it to be substantial and to come at the final hour.
Yeah. Like, oh my God. Like,
Oh
it's
no.
almost every it's almost every charge. They judge, can you please insert something here? Judge, can you please insert
Yeah.
something? I'm like, oh my gosh,
Yeah.
baby, you're gonna have to your closing. I'm talking about the
Yeah.
government. Your closing is gonna have to
Yeah.
be you're gonna have to put that tree together, honey, because
Mm-hmm.
you gonna the people the jury gonna be looking like, huh? We don't
Yeah.
understand none of this.
None.
None of this. This is confusing, you know.
Yeah.
So, I hope they just go get R. Kelly's paperwork. Go get that. Copy and paste. It would be all right. Because
Yeah.
this is crazy.
Yeah. They're doing too much, and I think they're
It's too much.
They're overthinking it.
Yeah.
Um, at the same time, if I'm correct, attorneys do, kind of bounce things off of each other and sometimes even kind of focus group it, if you will, not, in a
Um,
way to kind of see where are people leaning. So I'm sure, and especially with a case of this magnitude, I'm confident that they too are probably seeing and hearing some of what's going on social media, in the news, that sort of stuff. And then they're thinking, well, if we have a person like that on the jury, they're going to be confused. Let's try to fix it. But
yeah.
it certainly comes across quite differently. And I do think, because everybody thinks that I just want to lock up all the black men, but I don't. But the fact of the matter is, I do think that there should be limitations that are put into place in the legal process, perhaps in the future, or what have you, that prevent kind of some of that last minute, sort of stuff. I had the same frustrations in the Young Thug case. It was all these kind of
Yeah.
last minute, let's drop this bomb, whatever. I don't like that part of it, even though I
Yeah.
know legally it can be done. But I'm right there with you
Yeah. I
on
mean,
for what that's worth.
yeah, and I understand the process of trying to simplify it, but they got to be careful. Well, smarter. They got to be careful that they don't like the defense. In some cases, are accusing them of contradicting the indictment. Well, you can't do that. You understand what I'm saying?
Yeah.
Because that's either gonna mean that it's going to the I mean Diddy could walk, on appeal if you
Mm-hmm.
contradict that indictment.
Yeah.
Okay, so can't do that.
Yeah.
I don't know. I mean, I'm really I want to know. Now I'm gonna have to listen tomorrow to see because we don't have a conference tomorrow on this.
I thought they had a conference today at 12.
When did this come out? Because they said they were going to discuss this. Hold on, when did this come out?
And keep in mind that I got that because what is the man, the daily whatever that daily, the man that has been tweeting and going live,
Oh,
Inner City Press. Every morning, I listen to him with whatever his summary is of what to anticipate, and he has said that it was supposed to be 12 o'clock today, that they were supposed to have a conference on it, and then closing arguments should be Thursday and Friday. And so they could start deliberation, he said, as early as Friday. Now, like I said, I've been in and out because of meetings and stuff like that. So I could have missed portions of it if there is something else scheduled. Does the defense get an opportunity to do anything more with this? Or is it just kind of, this is what it is, and then the judge needs to make a decision?
Oh, they don't rest. The
Yeah,
defense
but
don't rest.
that paperwork, I thought that paperwork came out after.
Yeah, but I read the defense is on as well. Did you hear
But
that one?
that's all they get. They don't get any other arguments or like to stand before the judge and do anything besides the whatever the conference is.
Yeah, they can argue some more. They can argue some
Oh,
more.
okay. Okay.
If if he allows it, because they're I think that's why he set a status here and so not what would he say? Not a status. I don't know. He said some kind of hearing for tomorrow.
Okay. Okay. Well, I
That's what I
definitely want to
thought.
hear
That's what
that.
I thought I heard.
Okay. You might have. Again, I've been in and out, so I missed. Really, I've really been in and out the past 2 days, so I could have missed a whole lot. But I just really felt it was disingenuous of the media, specifically Harvey Levin,
Yeah,
an attorney, someone of a legal background, to get
yeah,
up there. And I mean, he was talking his big talk when, when I listened to it, he was just like, oh, this is this shows that, they're dropping all of these charges and what have you. I'm like, well, what are you reading? But at the same time, I kind of defaulted a little bit to him. I'm like, well, he's the attorney. So, yeah, if he's
right,
reading it that way, maybe that's the way it is.
right. But he pulled that video because it is not available. I went back and I was like, oh, he done pulled it.
Definitely. I'm not surprised or shocked at the same time. I'm like, yeah. And so this also gets back to the Harvey Levin issues that people have had over the years of, some of the information that they will put out via TMZ, and him personally will put out stuff that's just like, it's not accurate, like knowingly. Like at
Yeah,
some points, it's like now you're knowingly putting stuff out here that's not accurate. There's plenty of accurate information that they do put out there, but doing stuff like that. And again, as soon as he was doing it, all the blogs and everybody literally was going off of him and posting it
yeah.
as well. And people, oh yeah, see, he's going to be free, and oh, they
TMZ
dropped
said,
all the charges.
yeah, TMZ said it is right. But that's what I always said. I said
Exactly.
TMZ and what's that other one? Wait a minute, I said I said TMZ, then Law and Crime, and then Court TV.
Law and Crime said it too.
No. I said
Oh,
that's my order. Like
oh yeah. Where you getting
because
your information?
yeah. Like
Mm-hmm.
TMZ would be the last, and then Law and Crime, and then because the Law and Crime made a big deal out of that crazy dude that tied up Diddy money. That crazy dude that keep what's that Cardello Smith man keep finding all that crazy stuff on Diddy and won that $100,000, 100 million, or something like that by default.
Yeah. Yeah.
And they ran with that like it was. I'm like, hey, that man crazy. Yeah, why is y'all running with that? That man nutted in a fruitcake. And so yeah, they left it alone after that. Yeah. I'm like, that man
Yeah.
nutted in a fruitcake. Y'all got a whole show dedicated to him. He
Yeah.
nutted in the fruit. But then check this out, but I ain't gonna go by that no more because we said Jonathan, what name Oddie was nutted in the fruit. He is nutted in a fruitcake, but he showed no
But he
show up
wasn't lying.
that
And
time.
that's a and I thought they said at one point that he was going to take the stand. I don't think, at least from what I follow, he did not end up taking the
He
stand,
did,
but he
yeah.
wasn't lying either,
He
which is
wasn't lying, girl. I
wild.
was like, oh no, not Jonathan. Oh,
And
not
can I,
the person.
because I will say, I was even a doubter at time, like when I looked at the video at first, because it did seem somewhat outlandish. At the same time, you and I think, even had a brief conversation about it when
Yeah,
it was floating around at one point. And I said, but still, his behavior is pretty consistent. Now, he might have been under the
yeah,
influence, which made it difficult to make that assessment. But I said his
yeah,
behavior, however, is, it doesn't look like he's telling a lie, but the story sounds outlandish because these are things that a layperson we would never think exists or want to have go bump in the night. He was
right.
not lying at all and was referenced on the stand
On the
by
stand,
Cassie,
girl. Okay,
the
by
star witness.
Cassie. By that time, I was laid out. I was like, oh no.
I couldn't handle it. I didn't know what to do. I didn't know. I literally was sitting there with my mouth like,
Me
oh my
too.
gosh, he wasn't
I
lying.
was like, oh no, look crazy.
Yeah. And then it made me think even more, was he intentionally selected or used or what have you? Because it would look that way to other people.
Yeah. Yeah, I was like, oh my gosh, not Jonathan. He's telling the truth. He's telling the truth.
Look, free
Oh,
Jonathan. Free
yeah.
Jonathan.
Okay, you know, free Jonathan. Oh, here come Rosa Parks. Here come Rosa Parks, child.
Uh,
Free Jonathan. Free him. Let him
free
go.
him. Free
Child,
Jonathan.
child, how
And
he's running
another
around.
person that I was, some people that, and we can talk about it, of course, once it all unfolds. But I was shocked that a number of people did not take the stand. Um, Specifically, I was shocked that they were not able to track down Gina Wynn.
Yeah,
Major.
yeah.
We did not hit Jonathan Odie didn't make the stand. Um, who was the other? KK. Where is KK?
Where is KK? Baby, if KK would have took that stand, honey, I'd have been on this ground. I wanted KK on that stand, baby. KK like, KK, see, I knew, I said, why is this woman trying so hard? Because that's why you got to go look in the back. Why this
Mm-hmm.
woman trying so hard to get up off these cases? When I tell
Right.
you, she was trying to get up off all them civil cases, like, take my name off, take my name off, get me off, I got
Yeah.
nothing to do with this. And I was like, darn, this Christina Corum lady, she just went out. I'm like, look at
Yeah.
this nice white lady. She ain't done nothing.
Ain't no
Child,
nice
Christina
nothing. You
Corum,
saw it. You
yeah,
heard them text
child.
messages. Ain't no
Yeah,
nice nothing. Hold
yeah,
on.
Christina.
I got a call. I'm gonna
Okay,
jump right back off because it's gonna kick me out.
okay. Christina Corum is all up in the business. She all up in the business, y'all. I'm like, oh, Christina, KK. Ain't that terrible? Child. I gotta ask her what she think about this R. Kelly situation, child. Mr. Kelly, Lord, Mr. Kelly. What y'all think about Mr. Kelly? Yeah, y'all see how I put that the overlay on old Cedric. See, Cedric act like he was a friend to the channel. Now Cedric is super blocked. hmm Yep, he Cedric is now super blocked. Yeah, shaking his thing down there in my back office, shaking his thing. He's super blocked. I'm done with Cedric, honey. Cedric don't bring your name. What be wrong with y'all? Y'all the type of people that want baby oil and Astroglide and all this extra shit. Y'all them type, cause I just nasty, nasty, just nasty. And we thought Cedric was okay. Child, just nutty. Yeah, they denied that thing for R. Kelly real quick. Like with the Illinois one, it took 3 months for them to deny that writ. This time it took a month and a half. Took a month and a half, honey. compliment y'all. Okay, booty butts, I'm back. But y'all shuts down Monday. Oh, my baby Chris. Hold on. Any girl that I wanna, got what you say, number one. Where's my baby? Put a camera on my baby. My baby be performing. That's heat. When they be dressed up in them suits, and they be like, "You liking what you see? Hey, hey." That baby say you like what you see. Everything designer, that's on me, baby. That's when he be having talking about his little clothes, child. Ooh, Chris. Ooh, Chris. Y'all gotta tell me about Monsieur Kelly. Y'all gotta tell me about Monsieur Kelly. Damn. So the mm, I don't know what Bo next move is, child. To be honest. To be honest with y'all, I don't know. I don't know how many options he has. But I know ain't no goddamn text messages has been played that was supposed to be played. What I tell you. Not a proper legal argument, hunty. I don't know. I don't know. We might have a part two tonight. We might have some more guests. I don't know. But if we do, it's going to be interesting. Mm, 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 mm. So I wonder when Mr. Kelly gonna get out the hole. Who they don't move him. But from what I understand, he had a pretty decent prison. Yeah, they can move him. Because nobody wants to assume that liability, right? They don't, I mean, I'm not sure the judge is going to order any kind of investigation. If the BOP going to order some type of investigation, if they're going to get a special investigation, because they'll be like, the BOP investigating itself. So Mm-hmm. All these promises, promise this, promise that, ain't shit we seen come to fruition. These people done made some promises, honey. And what did I tell y'all? Watch his attorneys. Pay attention to what his attorneys do. Pay attention to what the government does, right? They are the only ones that can affect change. Now, there can be some contributors, but so far, well, I ain't gonna say it because it'll make me seem biased. And I'm not because I really don't give a damn. Um, y'all, I'm massaging my lumps and bumps. But I, oh, I, we've been promised a lot of shit and nothing, 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 nothing. I might get on up off him if I come back. Y'all know I got something special. I don't want to talk to no little Pookie Nams and no little Ray Rays. None of them. None of them. Oh, yeah, y'all do that. I can't. I'm done. I'm done. I had enough. It's always a reason I stayed away from niggas and ghetto, and they do so good. They clean up and fool. But see, you know what? But if I use my status checklist, that doesn't mean that they have to have status. But it's just some things on that status checklist that rule you out, whether you are a little Pookie or a little Ray Ray in there, some hood, some ghetto, some shit like that. Nope, nope, nope. I ain't interested. Some people comprehension skill is at like a third grader child. Y'all heard what I just read? That jury charge. Did you hear that? That jury charge is both sides trying to condense it, trying to make it understandable but comprehensible to average everyday Americans, meaning you, right? Now you see what I had to deal with, and you know, little Pook and Ray Ray now. I broke it down, Lord and that. Uh-uh. I'm good. Uh-uh. Like my, and I figure it out. Just kicking a bobo, I'll do that with anybody because I'm nice like that, friendly like that. But when you get on intellectual conversations, you probably need to stick to your peers, people on your level. They can be higher than you. They can be, you don't want to deal. You just want to deal with people on your level. So you begin arguments and shit. I ain't got time for that. And understand this, right? They're not challenging. And this is why I say, those text messages and all that extra shit and the setup and all that extra shit will never see the light of day, or most likely will never see the light of day. One, because it's not a proper legal argument in that case. Number two, his attorneys, they're not challenging whether or not he did this or he didn't do it. They're not challenging none of that. That's how I know that most likely those text messages and all that bullshit that we done been beat down with, that y'all wasted time and wanted me to read them, want me to catch a goddamn migraine and turn into epilepsy, reading that ghetto shit. What? I'm not doing that. I don't do that and waste my time. Mm-mm. I'm want to talk about stuff that is going to play in the courtroom. That's either going to get them out or keep them there. That's something I'm interested in. What's that argument? Mm-mm. I want to talk to people that understand. I don't care if I like you or not. I just want to talk to people. But this is YouTube. I'm not going to Starbucks with you. I'm not going to the game with you. I just want to talk to people that we understand and comprehend on the right around the same level. Because a lot of people, like, okay, a lot of y'all take y'all situations and what you've been through and what you've done, and saying, well, you see the people, other women have done the same thing. That's not a crime. Well, depending on the mechanics of it and how it's framed up, it is a crime. You know how much under the influence love making Adam may have? Huh? All across state lines. Do you know? Do you know? But I don't take that and apply it to, what's going on with these people. I know that, listen, when you read that code, oh, Lord. But yeah, we were told all them lies about them damn text messages. Oh, she said it's not now and all this shit. But when is it? Because it keeps getting, I told y'all them people aren't telling the truth. Just lie, 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 lie. I'm getting to think this shit's a money grab. I don't play games like that. Mm-mm. People lie. And yeah, and I stand up to anybody. That's the real me. You understand what I'm saying? And I always told you, if I need a team, it won't be nobody on him. You understand that? In real life, I don't play none of them games. None of them. I don't have people trying me and all. So I don't live in that type of society where people try each other and all that type of crazy ghetto shit. It's ghetto. Nigga shit. Hood shit. I don't be in no hood. Mm-mm. Even if I have to go visit in the hood, I go in the house and stay in there. And I might tell people that I'm cool, because of course, you always got to have your hood friends and all that type of stuff. I tell them where I am. They'll come by and visit with me to the house. Tell my mind, okay? Because when I came to town, I went to Yvette house. I told the one I always be talking to Tim and some other people, hey, I'm over here at Yvette house. They came over and saw me. But when I'm on the north side, I tell people I'm over there. They'll come by. Other than that, not me. So I don't be having people trying me and all this. I don't know no holes, no whole ads, none of that. So I don't know whether to get off here now and see what's shaking later. But Harvey Levin damn sure did pull that video. I don't use regular bloggers as sources. You notice that? I have, and I got about 2 or 3 sources, and one of them not Tasha K. That when I tell you gets it right, then I think I let her read. I think one of them read the paperwork to y'all because I ain't feel like reading, and I just played it on my thing. She gets it. Oh my God, she understands the law so well. I'd be like, yes, girl, yes, you got it. She's real good. I like her. You have to use it. You have to make sure your sources are right, honey. Mm-mm. And you got, I said I was going to keep this live clean, but I can't. Because that boy lied so damn much. I sure want him to find his grandbaby that I'm supposed to have. And I want him to prove to y'all that I'm Audrina Spencer. He needs to prove that Rhonda is Nia. He can't even prove that all his child support cases are closed. He can't prove that he take care of all his children and talk to them or none of it. He can't prove shit. It's a lie. Dude, listen. How you think I know that you keep running down there giving the people more discovery? I ain't got, listen, I'm an ordinary regular citizen. That's public information. I ain't asking no question about your goddamn case. When I can go look for myself, stupid. How about that? Mm-hmm. I had to get off here and then have to come right back on. So I'm just waiting a little minute. Y'all mind. Oh, I'm trying to. Oh, y'all, seriously. While we wait, let me see. Mr. Kelly is. I know he can petition the Supreme Court for some other stuff, but y'all, check this out right here. Why, when we start our question, or when I start the question and answering session, people all of a sudden get quiet? They be, they be talking as speaking as fact, right? Why you get quiet? When somebody asks you to prove something, you should be able to, prove it. Let me look up something. Let me see. Let's do a little R. Kelly recon. See if we can find out. Okay. Hold on. Hold on. So, okay, that's what I thought. Cause I know I told y'all right. I just wanted to make sure. So he has some more. He can, petition the court, the Supreme Court. And I told y'all, like, if he has another legal issue that he wants to bring, I'm talking about R. Kelly, he wants to bring forward to the Supreme Court via a writ, it has to be a different issue. Okay? I told y'all that before, but I just want to check behind myself, make sure I'm right. Oh, there go Mo Kiki. What's up, sweet?
Oh,
What's going on?
I
No,
think I
okay.
had you still in the background. Am I echoing or anything?
You good.
Oh, okay. Yeah, yeah, yeah.
Yeah, I was talking about the R. Kelly situation. I don't know if you heard the denials or whatever.
What is he trying to do now?
Oh Lord. No, well,
Has it been
um,
an update today or?
yeah.
Oh my gosh, what happened?
So with that, he they refiled it, but they asked for a Rule 33, which is a new trial and a bond, pending, schedule of a new trial.
Uh huh.
So the judge say, okay, well, I do have jurisdiction to do that, what I was trying to explain. The furlough and all of that, that wasn't. the right jurisdiction for that motion. But
Mm-hmm.
when he refiled it in the same Northern District of Illinois, this judge does have jurisdiction to hear a Rule 33. Um, so what he did was he denied the bond for him to get out, pending a new trial.
Mm-hmm.
But he said he hasn't made a decision on the new trial. Also, the Supreme Court on the 3rd denied their petition for a writ of certiorari. So now, so that brings us to, okay, both districts, the appeal was denied, as well as both writ of certiorari was denied um, to the Supreme Court. So that's where we are now.
Hmm.
So I was just explaining to them that, if he has a different issue,
Mm-hmm.
in the same case, he can petition for another writ. But, you know, mm, oh, that's you. Okay.
I'm sorry, I
Yeah.
pushed a button accidentally. You said that you was saying that he can do what now? Hello?
Child, where did Mo go? Mo, you could have stayed up here. Baby, I don't know what's going on. I really don't. Like all this. But I was trying to get her take on anyway, back to what I was saying. Hopefully tonight we can get into them damn text messages, honey. I know what I can do while we wait. Am I supposed to get that timeline together? I'm gonna go to that email. Go to my email. Y'all sent me some links. Oh, mm, Okay. I know what I can do. I need to find. Give me a second, y'all. TMZ talking about did it fate sealed by July 4th. Hold on. Y'all want to hear that? I don't know if they'll let me play it. Let me try it though. I'll try it.
It's June 25th, 2025, and today was a day where the jury was not present in court, and yet it was perhaps the most consequential day that we have had in the Diddy trial in a long, long time. We now know when the jury's going to get this case, when closing arguments are going to be, when the jury's going to get the case, and we have some estimates of when this case might wrap and we might get a verdict.
And I would say there were some fireworks, no pun intended, because the timing of this case is going to be profoundly impacted by the upcoming July 4th holiday. And here's how. Today, they're having something called the charging conference where the lawyers are battling over what the precise jury instructions will be. That's the packet of information they hand over to the jury to say, you need to find X, Y, and Z on the verdict form, and here's how you do it. It's instructions to walk you through the elements of the crimes, what you can consider, what you can't consider, and so forth. We're going to get into that. But on the timing, here's what happens tomorrow. Tomorrow we have closing arguments are starting, and each side, the defense and the prosecution, have allotted 4 hours.
First, the prosecution goes.
Prosecution will set up
for what, a day? 4 hours. It sounds like it's only half day, but if you take into account breaks, it's hard to listen to this stuff. It's hard for the prosecutors to talk for 4 hours. They have to put on their evidence, etc. 4 hours is basically a day.
It's basically a day. So they're going to put on their closing argument. They may reserve some time for rebuttal closing and so forth, but they're going to put on their closing argument first. That'll be all day Thursday. Friday will be defense closing argument. All day Friday, they will have their chance to break down that wall that the prosecution builds that we described earlier of why to convict Diddy. On Monday, and after the closing argument, Judge Subramanian will instruct the jury. He will
all the things they're negotiating today, they're actually going to give to the jury, present to the jury on Monday or on
Friday.
Friday after closing. Got it.
After closing, they're aiming to charge the jury. And then on Monday, we will probably begin deliberations. There's a chance deliberations maybe begin at the end of Friday if things go very quickly, but in all likelihood, they're going to be charged at the end of Friday and begin deliberations on Monday. Monday is June 30th, I believe. Tuesday is July 1st. Wednesday is July 2nd. Those 3 days are live in court, and the jury will be deliberating on those days. On Thursday, July 3rd, court is closed.
Holiday, right.
And of course, July 4th, court is closed. So this puts a lot of pressure for those 3 days of deliberation to build consensus quickly so that you can go celebrate.
So it is theoretically possible that judge could hold court open on July 3rd. Judges can't have this power to call the jury, to call their staff into court on a holiday. I think it's very unlikely here because this is not your ordinary case. This is a case that involves dozens of members of security from the bailiffs and the other security personnel at the court, and also the assembled mass of reporters outside. If there's a verdict, you're going to have to basically get, maybe up to 100 security guards to come and hold back potential protesters, people who are claiming triumph, whatever the verdict is, plus all the reporters. That's hard to pull off on a day when court is closed.
It's an extremely high, it's almost sort of
it's unthinkably impossible.
Impossible. He does have this power. He's a federal judge. You can have a skeletal staff, but to your point, you can't really have a skeletal staff with a case of this high profile nature because you need metal detectors, you need security, you need court staff, you need bailiffs. All those people have a court holiday, so you're going to have to pay them overtime. There needs to be extenuating circumstances. I just don't see it here.
So basically, so to go back to your point, there's basically 3 days of deliberation before a 4-day holiday weekend. And I think the point you're going at is that the jury's going to feel a lot of incentive, pressure, desire to wrap this thing up by Wednesday. And by the way, we're just not speculating here. There is a lot written on the fact that jurors are motivated by these kinds of things, and they do see expedited rulings in cases where there's a long weekend or even certainly a long holiday weekend.
Yeah, the dynamic is just fascinating because you would think when you go back to that deliberation room, you take a quick straw poll to see where everyone is at. Where are you guys on interstate transportation for prostitution? Where are you at on sex trafficking? Where are you at on RICO? And they're going to get differing. They're going to sort of see where everyone stands, what they believe, what they don't, how they would vote. And consensus will be driven by this time pressure. But they can't just say we're on different pages. Let's agree to disagree and just deadlock this case, because Judge Subramanian, who has had 8 weeks of testimony, is not going to allow a jury after a day or two of deliberations to say we can't come to a verdict, Your Honor. You have to be hopelessly deadlocked.
So what happens if on day 2 or 3 of deliberations the jurors do come back and say, Your Honor, we have a verdict on the Mann Act claim. We have a verdict on the sex trafficking by coercion, but we're currently deadlocked. We're deadlocked on the RICO claims. What does Judge Subramanian say at that point?
You got to go back.
Get back in there.
Get back in there. They can't come out. They can have reached a verdict on those other things, but they have to come out and read a verdict on everything. Yeah. So to the extent they're still deadlocked and there's a holdup on one charge that they're still debating vigorously, he's going to send them back and say, you've got to come to a consensus and give me a verdict. Now, you will get mistrials when juries are deadlocked, but it's not going to be after 3 days of deliberation. He'll say, fine, then come back on Monday and we'll do this again.
And he will intimate to them, he will suggest to them that I'm going to keep sending you back there until you reach a verdict, however long that takes. Now, there is a point where he'll have to declare a mistrial, but
has to be hopeless.
In an 8-week-long case, that is the single most high-profile case that he will probably ever oversee in his career, and that one of the most high-profile cases in recent American jurisprudential history, he's going to send them back there, I would say, for weeks before he lets them go. You have to keep getting back. The idea is to put pressure on them to come to consensus, to reach unanimity, and it's certainly not going to be 3 days. And so what happens on July 3rd, if they come back and they say that hypothetical statement to the judge about we're hopelessly deadlocked, he's going to send it back in, and he'll suggest to them that we'll see you after the 4th, and we'll see you for as many days after that as it takes to get this done. And then they're going to say, well, shit, let's actually try to do this.
Guys, we got time on Wednesday. Let's stay late and let's get this done before the holiday
Do you
weekend.
think this favors Diddy or the prosecution?
I'm glad you asked. I think it overwhelmingly favors the prosecution.
Me too.
In my mind, you can come to a very quick guilty verdict against Diddy based on the presentation of the prosecution's case. Remember, the defense took the risk of saying, we're not going to put on our own defense. So there's not a lot to wrestle with. They've seen cross-examination. They've seen the holes that Diddy's been able to poke in the prosecution's case, but they've submitted a tidal wave of evidence. I could very easily see the jury being overwhelmed by all that and saying guilty on all counts. Let's go home.
And so I think where I am on this is I can see a situation where it's 8-4 or 9-3 in favor of guilt. I can't see a situation where there's only 1 or 2 individual jurors who are holding out for guilt and the rest are in favor of acquittal.
I agree. The holdouts will be the people who want to find him not guilty.
And by the way, which is all good, but if there are 2 or 3 people holding out and they are going to hold all 12 of these people, and the alternates are there too, all 18, I guess we've lost 1 juror.
We lost 1.
We've lost 1. So 17 people, and you 2 people are going to be on the hook for keeping yourselves over through the 4th of July holiday and however long after that. And your other, all 17 of you. That's a lot of pressure on them to just sort of finally throw up their hands and
you don't want jurors to behave in a way that they can exercise their independent judgment. We want a juror to sort of look at the evidence and come to their own conclusion. But if you ever seen a movie like 12 Angry Men, there's a lot of pressure. You want to come to a consensus. You want to reach a conclusion, and people will lobby for things in that jury room to get to the result that they can all get on the same page.
There may be folks listening to us right now who are thinking, well, shouldn't they allow everybody to articulate their opinion? And if there's some people that don't believe that he's guilty, they shouldn't be pressured into it. That's not the way our system works.
Jury speaks with one voice.
Our system works that the jury has to duel it out, and we know some people are going to have to compromise their principles from time to time, and that's okay. That's the way our system works.
So that's on the timing. I want to now move on. So, you know, if I'm guessing, we might get a guilty verdict next week, but maybe longer deliberations. But it's an interesting dynamic. Now let's get into the nitty gritty, because the other big thing that's going on is, what is the jury going to have in terms of instructions? And the government, the prosecutors, filed a document saying, we want certain instructions to be in these told to the jury, and they're very telling.
Just to back up for just a second, it's hard to overstate how important jury instructions are. They really are the framework under which the jury has to operate. And so they're going to be told, in order for you to find come to a guilty verdict on count one, you must see where the prosecution has proven beyond a reasonable doubt these 6 elements or these 12 elements of that crime. And there's a checklist, and somebody with the foreman's going to have a pen and is going to be checking down the list that all these elements are proven. And so what's included in those elements is critical.
Absolutely.
At the outset, what the judge is going to put within those instructions is critical. So this document, sorry to interrupt, but this document was filed today where the prosecution is arguing what should and what should not be in these instructions.
And the biggest takeaway of all of this is there's an instruction that the prosecution wants in the jury instructions that will say earlier consent does not necessarily negate whether someone was sexually trafficked. And I want to put a fine point on that. Cassie's testimony and Jane's testimony in this case was that they were in long-term relationships with Diddy. Cassie's was 11 years. I believe Jane was 3 years, somewhere around there. During the course of that relationship, the defense has gone out of their way to show that Cassie was often enthusiastic about freak-offs. Jane would text lots of enthusiasm and loving text messages to paint the picture that these were consensual relationships in the swinger lifestyle that Diddy lived.
Real quick.
Yes.
Every time you and I talk about this, we get hate comments just accusing us of signing on to this idea that once consent happens, a woman cannot take away that consent, or that consent can be shown despite the fact that somebody's in an abusive relationship. We understand that is not the case. We understand that women are often abused, and this idea of consent, you never actually get consent. We get it. We're just telling what the defense has been arguing and what they're trying to get that omnipresent one juror to hang its hat on.
That's exactly right. And now, to blunt this, the prosecutors want in the instructions to say, yes, there may have been instances of consensual freak-offs, consensual sexual activity between Diddy and these women who've testified, but earlier consent to a particular sexual activity does not preclude you finding that later they were forced.
Right.
So what that means is all you have to find, jury, is that in one of these instances, Cassie or Jane didn't really want to go forward and felt compelled, felt coerced into doing these things. They're obviously going to lean heavily on the instance where Diddy showed a sexual video to Cassie on a plane, threatening to release it, involving Cassie, threatening to release it, according to the testimony, and then later asking for a freak-off that she felt compelled to take part in so that he wouldn't release the video. That would be forceful. The other ones where she says, I'm down to freak off anytime, that's prior consent, and they don't want that to derail the jury.
That's right. Now,
very telling.
The defense, I'm sure, in response to this,
I'm just stopping it so we can cheerio, we can woohoo, we can pop our collars. Remember, long years ago, I told y'all how important those jury instructions were. That's why we always went over them. That's why we stayed ahead of the game, right? We were all, like, when they were still going through the trial, we were already discussing the jury instructions, appeals, habeas corpus, so on and so forth. So, ooh, be smart over here.
Has argued to the judge that everybody gets this. You don't have to spell it out for the jury. Everybody understands that consent can be withdrawn. And by spelling it out to the jury, you're sort of putting, they would say,
thumb on the scale.
Judge, you're putting the thumb on the scale in favor of acquittal, of guilt. Instead, let's let the jury's allowed to bring their own experiences and their own knowledge into the deliberations. Let them do that. You don't have to suggest it. So by suggesting it, by you putting in the instructions, it almost makes it seem like this is what I want you to find.
Yeah, that you're sort of
Didn't
guiding
I
their
say
analysis.
that?
You're leading the
Right.
Didn't
jury
I
towards
say
a
that?
conclusion that they otherwise might not go down that path. So you're right. That will be a fight, and that's what's going on today.
Remember I said that? I said, pop my own goddamn collar. Then I say, well, damn, some of this gives like, you want them to find them guilty. Is leading towards guilt, and there's no other choice. Remember I said that? Run the tape back. Go, Angie. It's your birthday. Go, Angie. It's your birthday.
There's another big instruction about payment of money not being determinative either of sex trafficking. This goes fully to Jane's testimony because Jane, and they even point this out in their document, Jane testified that in April 2023, she and Diddy entered into a multi-year love contract under which he agreed to pay her rent in the amount of $10,000 each month. They're saying, I don't want the jury thinking that that transaction, that love contract, means they can't find that he also sex trafficked Jane. The compensation itself doesn't necessarily negate sex trafficking, and they want to make sure the jury knows that. I think that one is critical.
I do too, because I could see the jury, some members of the jury saying, well, look, she was clearly consenting to all of this because she was receiving money. She had entered into a contract, said basically, I'll have sex with you as much as you want, and I'll do these freak offs as long as I continue to get payment. He continued to make the payments, so she continued to have sex. And what the prosecutors are saying is, Your Honor, instruct the people that despite the fact that she was getting paid doesn't mean she was consenting to all of the activity.
That's exactly right. There can still be force. The government is saying these are not mutually exclusive. That transaction can work. It can be consent, but it can also be sort of a gloss that doesn't always work in their relationship. The last thing I wanted to talk about, and I think it's a biggie, is the government proposed that the charging language instruct that the jury may consider the defendant's cumulative conduct. Everything okay?
Yep, we're good.
Sorry. That the jury can consider the defendants what they call cumulative conduct. We've talked a lot about this case being very complicated because the nature of the relationship with Cassie and Jane were so long that there were just small tactics here and there. He was a vicious monster at times and beat Jane in that one instance, but mostly they were lovey-dovey. With Cassie, there was obviously the hotel incident and others that were horrific, but maybe the jury is thinking, yeah, he had some blow-ups, some domestic violence abuse incidents, but overall, this was a consensual relationship. They want the jury to be able to consider the cumulative weight of his conduct on the psyche of Jane and Cassie. This would be enormous for the prosecution to get in.
Yeah, just to plant that seed in the jury's mind that they're allowed to not just look at sort of individual acts, but just basically let's take it as a whole, which I think most jurors will do anyways. But you don't want, what the prosecution wants to avoid is certain jurors sort of picking and choosing what evidence they have. They want basically the instructions to say, take it all in the aggregate.
Now, if I'm the defense attorney, I'm apoplectic about this because this sounds like they want the jury to convict Diddy just because he's a bad dude. Just because in the aggregate, this is an unsavory character, which is not what we do in our justice system.
But which, by the way, is what the prosecution's been angling on for a long time.
And this is sort of
about the cumulative evidence. They've witness after witness testifying sort of the same stuff. The reason the prosecution's done that is because they want to overwhelm the jury with this idea that he's a monster. And that's what they're seeking in these instructions too. Basically, let's let him see it all, Your Honor. Let's let him consider it all. Is he a monster or not? And if he is, let's convict him on that.
Yeah.
And the defense is like, no. They have to prove each individual element.
Yeah, this is why there's a spirited debate going on. We'll see what the final instructions include, but this was I thought a fascinating window into just how tightly controlled the jury's deliberations will be. They'll have all the evidence, and then they're going to have these specific instructions that they're battling over. And
and lawyers like Derek and I nerd out over this stuff.
I love
this is where the rubber meets the road. And if you've ever served on a jury, you know how important those instructions are. It is critical. We've been talking since the beginning. Like everything is a prelude to the closing arguments and deliberation. And at the center of that, what the prosecution and the defense are going to be arguing to is the jury instructions. They will say, absolutely, they will put those jury instructions up in front of the jury themselves and say, the judge is going to instruct you at the close of these closing arguments at the following elements of the crime. Here's how we, the prosecution, have met each of those elements. Here how we as the defense have defeated each of those elements. So the jury
I'm
instructions
so
are
proud of y'all.
absolutely critical.
And every word matters. All right, let's go to some questions and comments we got from BMC. I understand charges were not dropped today because Diddy wasn't charged yet, but it was to slim down the instructions for the jury. Do you believe Diddy will get time served, or will he get at least 10 to 40? Okay, breaking down that question, no charges were dropped. This was about jury instructions and how they're going to present these jury instructions. There were a few things that were taken off the table because they didn't want to confuse. Judge Subramanian said, this is a complicated case. I don't want the jury to look at these instructions and their eyes glaze over and be so confused. Are there any things we can trim out? And they trimmed a few things.
The prosecution trimmed out a few.
The prosecution agreed to drop a sort of not have instructions about various attempted kidnapping, attempted arson, things like that. But it really just was a way to not confuse the jury. Now, your question of do you believe Diddy will get time served or will he get 10 to 40? I don't know. Juries are...
Depends what they convict him on, if they convict him on anything. I mean...
If he's convicted, I don't think he gets time served.
The one thing you and I have said is that if he's convicted just on the Mann Act, just as the interstate transportation for sexual purposes, illegal sexual purposes,
time served is possible.
You and I think time served is possible. Anything more than that, I think he's going to do some additional time beyond what he...
Yeah, I think he's facing some serious prison time. All right. Ms. G Dove says extortion should be easy to prove. Cassie's mom was extorted, so I believe that is critical whether the money was returned or not.
Remember, he's not charged with the crime of extortion. He is charged, however, with RICO, and one of the predicate acts of RICO can be extortion. So the question is, did they show that he had engaged in extortionate efforts of Cassie's mom and of Cassie herself with the videos that served this underlying criminal enterprise? And that's...
Yeah, look, you pointed out in your question whether the money was returned, because the testimony, if you remember this part, was Diddy's mom. He said, I need $40,000. I've invested a lot in your daughter, and you have to pay me back because it's a wash now that she's with Kid Cudi. Sort of pressured her to give him 40 grand, this guy who's worth 9 figures. But anyway, said, give me the money. He then took her money. She took a second mortgage on their home or something to that effect. Sends 40 grand to Diddy, and he subsequently returned the money.
After he and Cassie then make up.
That's right.
He sends 40 grand back to the mom.
Does that undo the offense? No.
Sending it back to the mom is, frankly, makes him more culpable.
Yes.
Because it's showing that I was just using it as leverage to get your daughter back to doing freak offs.
It's consciousness of his wrongdoing.
That is something we haven't talked about enough. What a huge fact that is, that he returned the money after he and Cassie get back together. Things are good again. Sends the money back to mom. So that sort of proves that the reason he asked the mom for money in the first place was leverage to get Cassie back in with him.
Absolutely. And to your direct point, returning something, if you steal something from a store, returning it does not undo the theft. So the return of it, to Jason's point, actually makes it kind of worse for him.
I love SAS 1000's question. Would this case have gone differently if there were cameras in the courtroom? Cameras affect the litigants 100%.
That's
Whether
a
the
great
outcome
question.
is different, I don't know. But the presentation by the lawyers is different. I think there's more of a performative aspect of what the lawyers are doing. More
and the
eyes,
witnesses.
And can you imagine if a camera was stuck on Diddy the entire time? I mean, obviously Diddy was trying to be on his best behavior for the purposes of the jury, but the court of public opinion is very important to Diddy. We know that, and it would have been more performative.
I absolutely agree. Look, the OJ trial was televised. It changes people's performance.
Yeah.
Johnny Cochran was very theatrical in his presentation. The witnesses behave differently. A camera staring at someone changes behavior, and it changes sort of the perception of people in profound ways. I'm not saying it would lead to guilt or innocence, but it would certainly change the feel of the case.
Let me ask you this. You and I we work for a media enterprise, so we love public trials. They're good for clicks and ratings and podcasts and everything else. So we like them from that perspective. What do you think more generally about cameras in the courtroom? Because they do affect the litigants and maybe affect the outcome of trials.
I don't know if you will agree with me on this, but I think we should have more televised trials.
Yeah.
And the reason I say is...
So we can get more clicks?
Yeah, I like the clicks. And also, the public has a right to know.
I agree. I agree completely.
Courtrooms are supposed to be open and shouldn't just be the people who showed up to the steps of the courtroom. We have every right as citizens of this country to know what goes on in our judicial system.
I completely agree. You and I are both old enough, myself certainly, to remember the OJ case and how that fundamentally changed every American's understanding of the judicial system. And I think we even did that in the Amber Heard. That was sort of a more farcical, I think, thing that happened there. But nevertheless,
we have a right to see that too.
We learned a lot about it. And imagine how much we would have learned about evidence and lawyer presentation and closing arguments and jury instructions if we had cameras in there.
You're
Instead,
right.
you and I are left to, answer.
You're taking your civics lessons from two clowns instead. All right, so let's go to some comments. Quantum Hustle says, okay, I rock with these guys.
Love
I hope
it.
that means us. All
I
right,
hope so
great.
too.
And Nancy Nicole says, Derek and Jason, thanks for a great show. Johnny Cochran was a fantastic lawyer.
Nancy Nicole said that. Johnny Cochran was a fantastic lawyer.
I couldn't agree more. He was one of the most skilled and talented lawyers. I know his reputation is somewhat mixed in certain circles.
Depends who you talk to.
Depends who you talk to, but as a legal talent, he was second to none as a trial lawyer. He really was incredible talent.
That is a true statement. All right, guys. See you tomorrow.
Okay. Ooh. They talked about everything. We did so good. Go back and replay. Then I said it sounds like they want you to find the man guilty. Oh, yeah. I don't know none of Beyonce songs, honey. Okay, now how the hell? Which other video? Okay. Let me see if y'all won't let me play this. Let me see if I can play this.
Comprehensive skills that we have as a unit on YouTube. We can't even stay on topic. All we trying to do is straighten our shit out. That's it. Straighten our shit out. Internal shit. But if they hear, of course they gonna come in for it. That's fine. But don't get it twisted when the fuck I say something about my life. I don't need nobody trying to correct me. That don't make sense. Now, if you was there and say, oh, Winslow, that ain't happen like that happened, then I might say, you know what? You're right. You're right. Damn, it did happen like that. Come on, man. Don't play me like that. I don't do that. I don't do none of that. And this fucking YouTube channel from Team Truth to Team Truth LLC was getting fucking out of order. It was getting confusing because people wanted it confusing. Because one thing I do know, I just watched the thing on guy Jason, Hollywood Unlocked. Jason. He just went on there, right? He just put up two things the day he was dealing with a situation. He was arguing. This is a sidebar, something totally different. And dude went and got a business entity now from words that he used. I didn't hear nobody going back at this man. Woo, 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 woo. Because you know why? That showed me he has enough intelligent people over there to understand what is a business and what is a YouTube freedom of speech type style organization. That's it. That's it. Supporters. That's it. So when he slapped that paperwork that he went and processed and made it a part of his business entity world, he knew that's a whole nother level. And he can't be, if it's messy what the business is, then it's messy. That's fine. But if it's not, then he has the right to make whatever disclaimers he want of his business. But evidently I don't. Because motherfuckers want to tell me about my business more than me. Then for all that need to know, I never said Larry didn't do shit. From the time I met Larry was a major part of my information thing that I needed on a whole different level. On a whole different level. See, PIs ain't cheap. So when Larry came, he was a blessing. He was a blessing. So when he was able to provide the unique skills that he provided, man, he was my angel there. He was a piece of the puzzle. And then when he wanted to get more involved and fight, I was like, oh, man, I love that you did this XYZ for me, but bro, I don't want you in this fight. I don't want to see your family go through what my family going through. I don't want to see you on here being shamed or lied on and this and that. And I said this at his kitchen table, his goddamn whole family right there. So I don't have to fucking lie. So some of y'all may need the fucking truth. And I begged him, say, yo, don't do it. You know what he looked at me in the eye? I said, yo, I'm in. I said, bro, you in? I'ma always be right here beside you. And that's it. And then from there, that's when we built. That's when he came on. I was already doing my lives. I was already on my goddamn IG. So I'm confused on what y'all thought y'all knew when y'all keep saying Larry started this and evidently he not straightening the shit because I watched 3 of his goddamn YouTubes after that lives and he ain't once said straighten it. And not one time do I ever talk bad about Larry. I give him his props on everything he did because I appreciate it. But when it comes to a point where he is what happened? What happened? Hold on. What? See, one thing you can get my attention when a motherfucker telling a lie. You can get my attention. Especially somebody close. Somebody far, I don't really know. I don't give a fuck about them. But somebody close that's in my circle, because I've been lied on. I've had niggas who love me, to love me all their life through the streets and this and that, and they the same ones that sent me to prison. So that love shit, when motherfucking one thing my mother always told me, when a motherfucker snake bite and he miss, always understand it's a snake. So you can try to give people the benefit of the doubt and you can move on. They can show you, well, okay, that was this some shit that happened. Or they can show you your true self and be like, this is what I like to do. And this is where we at. This is where we at. This is where the fuck we at. I don't run around this motherfucking line. I don't take credit for shit I didn't do. And I don't speak on shit that I do for people. But make no mistake, ain't nobody gonna sit on here and make me like some goddamn clown or some broke down motherfucker that just was crawling around, moping and poping, and here come a hero came and saved me. Motherfucker, I was in the fight knee fucking deep. Financially knee deep. Every motherfucking angle covered knee deep. The fuck is wrong with the people? So for y'all to say, oh, I'm a day one, you couldn't be a day one because your day one had to start with me. So please don't get on here with this dumbass shit. It's starting up. No, let me rephrase that. Before everybody get this, your day one had to start with me and Tim Savage and his family. That's who I had to start with. Like all this shit, man, I don't do this shit. But every now and then, man, somebody need a clearing out, man. Somebody need the truth to hit. And we can go deeper. We can play this back forward YouTube game and all this shit. But I promise you, I'm not the one that play them type of game. I'm not the one that's going to keep playing for this entertainment because I don't get shit out of it. I spoke my truth. I speak my truth beside people. I respect people the way they respect me. But when I find out motherfuckers backbiting and stab me in my back over and over and over and over, I don't confront them no any type of way. I call them up and I speak to them. And if shit ain't to my satisfaction, I got to analyze it. I got to evaluate it. And I got to say, well, do I want to get past this? Or maybe this is a sign to leave this shit alone. Don't nobody tell me, oh, I don't like him, or I don't like her, and this, that don't work like that with me. Every situation where somebody was kicked out or moved or removed from Team Truth, I talked to them personally. Majority of them, I'm going to say that, not all of them. Majority of them, after the fact, they didn't come back because I never went against Larry. He was dealing with that shit 24/7. I was only dealing with it maybe 14 hours a day. I was more dealing with the people involved with having my daughter than this YouTube shit. So I was more moving around than sitting on YouTube. I couldn't do that. And that's what I commend him for. But evidently he didn't hear that the other day on it because I keep hearing these Team Truth shots and these subliminal messages that motherfuckers like throwing. So if this get y'all views, clicks, and fucking commentary, then run with it. I'm glad that I seen the true colors. And if you don't run with it, then I see that maybe I might have been looking a little too deep. Maybe I might have been a little too stern. And maybe I owe somebody apology in the upcoming weeks, this on some of the surface. But make no mistake, bro, I don't play these fucking games. I don't play these games. I stress that shit to anybody that meet me, that know me, that come in my circle, and people that knew me all my life. I'm not going to play all these dumbass games. I don't do that. I've been a victim of motherfuckers talking about them in the street, behind your back. The same motherfuckers you done facilitated 50, 80 motherfuckers change their life in your lifetime of whatever you was doing. So I know what it feel like. So that's why I don't do it to other people. So for me to feel like now I have reached a certain point in my life and I got people around me that understand this and fuck with me, and then some shit like this happened, yes, it's personal to me. It is fucking personal to me. And that's why I can sit on there and say I have respect for somebody on the other side because they never showed any difference. They are who they are. They speak how they speak, and I can respect that. They getting their bands. They getting their money up. That's what they supposed to do. They already said they don't give a fuck about really their fight. So, okay, they living their life. I'm fine with that. But when you talk about somebody who you allow your family be around, they belong around your family, that's a different type of level shit for me. And I don't appreciate when I got to find out shit and you ain't man enough to straighten some shit that I tell you is a problem. But you man enough to listen to some shit that somebody tell you that don't do nothing but got gossip shit going all over the motherfucking internet off of everybody page. And you can call every goddamn YouTuber and they're going to say that about that individual. And you feel like you picked them over me. Good. Because we're not gonna separate the conversation saying you're not gonna pick them over the ones that's telling me. They don't tell me shit. Nova here and Peggy here. They always spoke there whatever they felt it wasn't right. And they're 9 times out of 10, if it had your name in it, they'll gurn fuck it to you. They'll tell anybody. Angelo be like, well, giving you the benefit of the doubt. telling them they may be looking at it wrong. No, it ain't like that. I'ma talk to them. That's what I do. I don't fucking condone any of that shit. And that's fact. How they feel is how they feel, and that's what I tell them. I can't get into that. How y'all feel, whatever happened with y'all, I can't get into that. And I just leave it like that. Y'all got to mend y'all shit the way y'all mend it. And I go to him and tell him the same goddamn thing. So I'm confused on why people acting like they don't get that part. See, I don't play these games, but it showed me, since you believe them so much and you Sam is so much of your Bible, that's what you got to be giving her some bullshit. You had to be feeding her some bullshit. And I was hoping she was on here to ask whatever question she wanted to ask so she can get her answer, because she said everybody in the Zoom heard me say that. I know all the people who's in the Zoom, well, at least most of them, and I want to hear somebody say, yeah, Angelo, you said that. That's all I want to hear, because I know the fuck I ain't said, because I wasn't in there initiating the conversation. I was invited in there to answer some fucking questions, and that's what I did. This shit crazy, man. This shit not a game to me, man. People got lost with this shit, man. Lost with this shit. Have I ever said Larry didn't go through shit? His family didn't go through. I was right there for it. The reason why I don't talk to one of the YouTubers is because of the disrespect he said about Larry's daughter and his wife and all that shit that I can't get out my head. See, I understand why you attack me, but to attack somebody else just because, that was my problem. Now they made amends with it. That's fine. I don't be around dudes that just say what the fuck they want any type of way around motherfuckers and speak however they want and think that's cool. I don't. That's not something that I do and something I'm going to promote. So I stay the fuck away. I stay out their lane. Hopefully they stay out my lane. That's it. They can keep getting their money. I understand you got the right to talk about me, my family. That's fine. But I ain't going to let no motherfucker that's close to me sit there and tell no bullshit. I ain't gonna let nobody sit there and be a close motherfucking acquaintance of mine, like damn near a brother of mine, and I gotta go through this shit back and forth with 3-4 weeks straight now with some he say, she say shit. What the fuck I look like, man? This shit crazy, man. I don't be on here with none of that. I talk to do. I text him. But see, he got a point to prove to y'all, and y'all got a point to prove to him. So y'all stay loyal. Do whatever the fuck y'all need to do over there. But leave me the fuck out of it. Because I don't play these in-between games. I don't be on no fucking private Zooms talking about none of y'all. I don't have fucking time for that. And it's crazy that y'all think we do. Then people run in the chat, oh yeah, because such and such told Angelo that. And I guarantee you that's who told him to come over here. No, how about me coming in my last chat, Diva the Dawn channel, Larry sent me the fucking link. So in case y'all didn't know that, who fucking sent me the link was Larry. Me and him talked earlier and sent me this link. I wasn't going in there at first. Sean was going to come on there and not to fucking destroy the young lady, Sheena. She went on there to speak her truth because nobody knew her truth but Sean and fucking Sheena. That's it. But that quick, everybody was hyped up for the bullshit. Like, this shit crazy, man. This shit crazy, man. Y'all, this shit baffling to me. It doesn't make sense, man. And we're going to keep going and keep doing this. We got right now one of the heaviest points of this whole situation get ready to come up. And this the shit y'all think we're going to be internally battling and then trying to fight ops and do all that. Nah, bro. I don't got time for that shit. I never stop praying for what trolls. Just tag me which ones it is. I pull them out the chat. Cause I see it's bothering y'all. Though whatever ones, send it to me real quick. So what I'm telling y'all, man, I never stop praying for Tim, his wife, and their situation because I am a father who know what the fuck they are going through. I know how I feel to be absent of a child. in a situation where you know you some days you don't know if they living or dead, and some days you just know that they living, but you can't say you love them or hug them and all that. I know that. So no matter what me and Tim ever went through, me and Tim stayed in contact. We still text here and there every now and then. If I need Tim to call me, he'll call me, this and that. I never lost. But I think somewhere along the line, somebody lied to them too. And when next time I talk to Tim, I'm going to clear up some shit for him too. Because somewhere somebody got shit wrong and claimed a lot of shit that wasn't their motherfucking story or they goddamn truth. So we can get it all open and out here. You know, so that's the whole thing. That's the whole thing with all this shit, man. I don't have time for the in between and none of this shit. No, who had this? This is way bigger than fucking YouTube. None of this shit on YouTube amounted to any other different things when after them people got them. Did it help? Maybe some shit helped, but that's it. All that other shit, this shit is bullshit. It's bullshit. I'm just telling y'all, man, in between this shit is whatever. They have the right. If they just saying free R. Kelly and all, I don't have no problem with that. That's not a distraction and all the shit. They got a point to feel who they want to support. I don't got nothing to do with that. What I do got something to do with it is when people is considering themselves a part of something that can be big and huge around the world, that can affect people around the world, that has something to do with people's personal space being violated by a predator or pervert in their family. Then we have a problem with that. That's my problem. We can't share somebody's secret and then we on the internet acting like fools because the first thing this person gonna do is go into a shell and say, you know what? I can't. Why the fuck I tell them that my story? Now they know what the fuck happened to me and this and that, blah, blah, blah. I can't do that. That's not what Teen Truth is. And everybody that heard Sean for the first time, she's a very articulate woman. She's dedicated from every core in her body to this shit. She also was a victim, as she explained. And a whole lot of women that's built up Teen Truth has been victims and men. So no, I'm not gonna allow a fucking shit show on this and it spill over to Teen Truth LLC. But I didn't have nothing to do with it because I didn't see it. So therefore, I only address shit that need to be addressed. No, I'm good. Listen, we ain't gonna listen. This is what I'm trying to tell y'all. This shit here is got way out of hands, probably on both sides. You know, y'all got motherfuckers, we sat in tune because we couldn't stand two of the people over there because they come at, I think Larry got valid points of certain shit that he been through, that he has to fight a certain way, and I never got in his way of fighting. And I did the okay, and I never ever took anything from that. I actually sympathize for him and his family, and anytime I can, I jets out there just to show him I'm here. I'm in the fight. He called me up. There's some serious shit like that. I come in. I speak my thing on the situation to the individual who may be doing it, and then I'm gone because it's YouTube shit that's gone too far. These motherfuckers at the point, everybody, and I told y'all very beginning, the way this YouTube shit gonna be, somebody gonna get killed. And it should never have to do this for agree and disagree. That makes no sense to me. That probably make no sense to nobody. Nobody. I don't understand anybody that wanna. Hold on, I'm sorry. That anybody that wanna go. Can y'all hear me now? Anybody that go through some shit like this. You know, it's real trauma over here, man. So tell why sometimes when these women go at people so aggressively, because they've been through the trauma. And this shit is just kicking back off some shit that they feeling, and we don't understand it because we're not victims. But we can have an open ear and a sensitive part of us to say, you know what, let me listen. Let me kind of fall back and let them, you know, say their piece, speak their piece. And that's cool. That's how you do it. But all that other shit, man, we gotta let that shit go. We gotta let that shit go, man. This shit crazy. This shit too much. And Yamika, you know, crazy shout to you. that you know, she's been through a lot. She's one of our major supporters too. Man, everybody got a fucking story. Everybody got a story. Let me hold it. Yeah. Everybody got a story. No. Everybody got a story, and everybody's story is different. But guess what? It's all the same in the realms of abuse. And when we stop really realizing that, and we taking this shit for granted, this is what happened. We can't take this shit for granted no more. We gotta stop taking everything on this internet for granted, because guess what? That individual that did it, he got to answer for his own shit. The young ladies that been through it, they gotta live with that shit, man. They gotta live with it. But guess what? Outside of them, it's women way before them that been victimized. It's women way before all this shit that been sitting in a corner with no voice, trying to understand as grown women. How in the fuck did they parents didn't speak out for them, didn't fight for them, didn't do this for them? And now they felt a YouTuber or a family on YouTube that sat there and put together something that opened up a door where it was open for communication, where you can go there and deal with other people that been through the same shit. And people can be sincere about your shit. Like, come on now, like this shit going on, man. This shit don't make no sense, bro. And then where I would never thought this would happen internally with me, because we open and talk about everything. So how in the fuck do I got one of my motherfucking right hands behind my back going for any motherfucking thing that come across his head? I mean, his ear. Make that make sense. Well, we ain't really talking about that. And I think you got some daughters, man, some real tough looking daughters that you need to worry about, DJ. I really think that that's more what you need to be worrying about. My daughter job is in the entertainment field, and she probably make a lot more money than probably you and your kids put together. I can guarantee you that one. So when you get on here and you say out of line things because you think you can say it with that trashy ass little background you got from being a fuck boy in the street, nigga, that ain't gangster in my book. That might have scared other people. That shit showed me you was a fuck boy. You was the type of nigga that I had pay you less, a bare minimum, to do some dumbass shit because I don't value your dumb ass. So when you come over here, bro, speak on my daughter, understand that she make more than you and your fucking kids together. Understand that one. So you should have just stayed in the background and shut the fuck up. So now back to this, you know, back on a real topic. That's what I mean about ignorant motherfuckers. He got his own fight over there. I ain't over there interfering with they fight. But niggas can't help themselves. This how they eat. This how he need money. And I get it. I get it. But don't come over here saying shit about my kids when you got strong looking kids, girls and boys. You have to stay in your fucking lane. You know, it's all good though. You know, that's the problem where people hear some shit about somebody and they think that's monstrous. That shit ain't monstrous. It's far from monstrous. It's monstrous. He was a fuck boy. So anyway, let's get back with this. And, you know, we go back to, you know, all this shit, you know, this the dumb shit. Listen, bro, I wasn't going to delete you, but I'm going to delete you because you say I'm clout chasing. Nigga, look at your videos, you stupid fuck. Every video got my name in it with your shit. You lucky I ain't shut your shit down. I've really been nice to you, let your ass eat because you was homeless. But don't keep playing with me because I got good lawyers that don't got shit to do but shut down motherfucking YouTube channel. Think you better ask about that. I let you ride with that shit with my name all in your shit. So, nigga, I don't play them game. Fuck, nigga. So get off my page with that dumbass shit talking about I'm chasing clout, but you got my name on your YouTube channel. Make it make sense. Get the fuck off my page, stupid ass. That's what I mean, uneducated dumb motherfucker. Now he'll go back, he'll take that commentary and use that the best way he need. You know, I get it, but don't get on here and say stupid shit, man. You got a lot of people that support you on the other side. They're not saying ignorant shit. They speaking their piece. They like what they like. You know, come on, Red, straight at my daughter. Like what grown ass 50-something-year-old man get on here and talk about my daughter. Talk about your strong face looking kids. You need to worry about your goddamn daughters. That's what you better worry about. Now, back on this. I'm sorry. I apologize. This is how I get, because this is a real sensitive shit, and it ain't had nothing to do with my daughter nor R. Kelly. So why the fuck is it, I'm having over here back in these same conversations every time? Because motherfuckers come over here, this all they know. This is all they know. You can't get on here and say, well, you know what, yo, I kind of disagree. I had somebody that was abused and challenged some of the shit we talking about. But they can't, man. They got to go back to the same thing. That shit crazy to me. Crazy. Makes no sense. That's crazy, man. Then they say dumb shit. So back to this, man. I ain't even want to make this shit long. I don't even know what else I gotta address with this shit. But what I'm telling y'all, man, I don't have no problem with all this straightness something or telling my truth. But if you want the truth, ask me. I done probably talk to everybody on here, probably on both sides, some way, frame or fashion. If they called or DM me, I talk back to them till they start talking crazy. I don't duck anything, because guess what? You may be on the other side, but you may needed to know something that nobody else knew, and that you needed to know to make a decision. Say, oh, well, damn, yo, ain't a fucked up dude. Maybe that was a lie. Okay, let me ask him. And then you ask me, and that's it. That's how I go. I move on. You know, sorry, I keep getting phone call. But that's all I'm telling y'all. Like right now, man, this shit crazy. You know, it's crazy. That's all. No, bro, big homie, let me explain something to you. I don't do no crew, bro. I'm not into no crew. None of that shit that y'all conspiracy y'all got. I'm me. I'm not in no crew. When I don't deal with somebody, I don't deal with. I don't give a fuck where they from. They could be my next door neighbor. Hold on. All right, I'm back. So I don't do that, bro. I don't play the 50. If I don't fuck with you, I don't fuck with you. I don't care where you're from. So let's understand that about me, bro. I don't play the in between. I don't need a connection. I don't need to be validated, and I don't need no crew. So I'm not, listen, man, y'all in the chat beefing with each other over nothing. That don't make no sense. That's crazy, man. That's what I mean. Like, this is where I say shit too far. You know, L was on here, strong speak about whatever he felt that he brought him in this fight. Wasn't just me. It was the passion of a daughter that he had the same age that he was connected to. The way it's most of these people on this internet are. But in the midst of all this, man, being connected to somebody, we also need to also stay grounded to who we are. We need to stay grounded to who we are. We losing it on here, man, looking like goddamn fools. You know, I'm just not into that, man. So I just wanted to address this shit, and now I will allow some couple people to ask some questions that they need to know that was internal. All this other shit, I don't care nothing about. I don't care how many motherfucking YouTubers got my name. I don't really give a fuck about none of that. I let that shit go. I don't address it. None of that shit. It's cool. They gotta live. They gotta do what they gotta do. But when it comes from internal, it hurts. It hurts. And that's all I'm gonna say with that, man. I'm done with all this back and forward shit. So I'm just telling y'all, man, I never asked for, I'm gonna say this one more time for all of the ones that didn't hear it the first time. I never asked anyone to not use Team Truth that felt as though they stood from day one and fought for Team Truth. Every channel you get on, what I'm telling you is, when you talk about Team Truth and Team Truth LLC, Stop confusing it like y'all don't know the fucking difference. You can go to the website and see the goddamn difference. It says nothing in there about what's going on in YouTube. So I'm confused on how so many grown reading motherfuckers on our end, on our side, can keep confusing what the fuck that it means. It makes no sense to me. Makes no sense at all to me. So that's all I'm asking somebody. You know, make it make sense. Man, if I'm on a YouTube channel, I'm getting bombed and they going back, I understand it because I get it now. Because my own motherfucking side was sitting there sending motherfucking subliminal messages for me to get toe up while I'm asleep and wake up and have to fight and all this shit. When it's happening internal, that's why so much shit be on the internet and false narratives be going a certain type of way. Because we had the same problem as everybody else had. Motherfuckers want more gossip and more confusion and more goddamn anger and threats and want to kill each other than you want the truth. And I feel you on that. And I definitely feel you on that. And that's the sad part, Nova. And I do, on my end, apologize because for some reason, they have us like, man, you've been on the phone talking for months and months and months. And ain't none of that true. They feel like if you and Peggy call me and say anything, it's oh, Angelo, this react. Like, I don't understand that. We talk about a lot more things than this shit. And we just recently start talking. So I'm confused on what people don't understand about this shit. And when I say something, somebody looking at me sideways like I gotta lie. I don't have to fucking lie to nobody about shit. It makes no sense. It's just crazy. I respect everybody on here. I respect Larry. I respect everybody that on here. I respect Sam and Alicia. I just think that some point on this fucking YouTube, everybody lost themselves. That's it. I could be completely wrong. But I'm damn sure ain't having nobody sit on no goddamn phone and tell me some shit they said I said and it was a goddamn lie. That's what I'm not going to do. And I'm not going to fuck with be in somebody's face or on the phone with somebody who sit there and listen and let them egg them on to make it like it could have been the truth. If he didn't straighten it, that showed the length of our relationship and friendship. That's it. That's it. Shit crazy, man. So, you know, Nova and Peggy, I don't know what y'all went through. I wasn't there. I don't know how y'all so much disagreement with L and where it turned left. And I spoke this to y'all in Zooms, on phone personally, and everything. And I never got in it. And I always took Larry's side or gave him the benefit of the doubt with y'all or try to get y'all to look at it in a different perspective. So for that, this is the truth. There ain't no fake or fiction. So he got to deal with that. And I told him this over and over. So all that shit, everything, I don't do this behind your back biting shit. So for it to happen to me is fucked up. It's fucked up, and it just let me know because I'm prepared for about anything. So it don't surprise me. It don't surprise me, and that's why I don't trust no one. I don't trust nobody. I'm just being straight up. I trust no motherfucking body. I keep my eye on everybody because you never know who the fuck it is, the person that's faking you out until they bite. And when they bite, at least it don't have to be a hard bite. You could kind of already expect it, and it could be a snag. All you got to do is sit patiently and wait. Let people show their true colors. And I'm not saying speaking on one person. I'm not speaking just on Larry. I mean worldwide in general. Me and Larry got issues. That's what we got. Me and him got issues. We may start talking. We may not. I don't know. It's a lot of shit that need to be cleared up, that need to be straightened. And long as Sam has a lot to do with it and a lot to say when she sat on the phone with me today and tried to tell me what the fuck I said, and that was a goddamn lie, I'm done. And once he showed me that's the side you chose with, that ain't Team Truth. And that's when I'll get in and I'll explain that's not Team Truth, period. Always, Queen. Thank you. So on that, Nova, we ain't gonna make this all about y'all. And I'm sorry I had to put certain names out there, but I just don't do this backbiting shit. I'm not gonna sit on here and do subliminals when it's internal. If it's internal, I think we should speak goddamn names because it shouldn't even happen in the first place. Because nobody's gonna sit there and go on there and say, "Oh, I'm going over there and I'm gonna do this to Larry." The first thing I said, "Nah, no, you ain't. Let that shit go. Look, it ain't worth it. Blah 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 blah." That's it. I called Larry up there. What's the problem between you and that person? Man, you need to fix that shit, man. See, I don't have to lie about my shit, and I'm tired of it. I'm tired of every goddamn night I'm in the middle of something and some other messy ass shit come up from some messy ass person. Y'all ain't trying to get justice for the victim, and you ain't trying to get motherfucking justice, I guess, for y'all supporting the pervert. So what the fuck is we in the middle of? We might well stop using anybody's name and just go at each other, because that's all the fuck this internet shit is. Because if it's about justice, it's about that, and then speak like that. It ain't about all this other shit, man. Who not participating? Who is participating? Who may be this person? Who, man, get out of here. Y'all all adults. Everybody can speak their fucking mind. Y'all can either tell the truth, don't like it, disagree, or let it fly. That's it. But Larry not too far away. I'm quite sure you can text Larry, call him, speak your truth, have it out, deal with it, whatever, and that's fine. And that's what I tried to do. But when it get to this fucking point right here, where now you choose somebody over me, and then they think they that motherfucking bold in their life or whatever they got going on to call a motherfucker up and cuss and fuss and talk, man, that's crazy to me. That makes no sense. That makes no sense. Makes no sense at all. I can't say who lied, who didn't lie, what was told, because I wasn't in these personal groups and none of that, and that's why I always defend him. And everybody on there that ever knew me, the first thing y'all say, "Oh, it's a lot you don't know, Angelo. That's something I want to ask you." I say, "Ask me." I don't have to fucking get on here and lie. I ain't gonna misrepresent nobody on here because I know how deadly this shit got. I know how bad this shit got. I know how many people on this motherfucking internet didn't even pay attention, don't even take this shit of the Capitol being stormed and taken over here in the United States. That we have a race war starting, that people not paying attention because we so engaged in this dumbass shit and already at war wanting to kill each other on this. This don't even make sense to me. Like, it ain't even a timeout. Like, hold on, let's take a timeout, yo. We need to focus on this. None of this shit. None of this shit. Like, you got to evaluate yourself. Like, when the fuck do this be consumed more importantly than what can happen when you go out this fucking door? When you go to the store, when you driving down the street, or maybe in the whole city? Like, what the fuck is wrong with y'all? Like, we got to focus, man. We got to get back to strength, man, understanding what it is and looking at the world differently. We're not going at the one person or because they have pedophilia tendency or behavior and pervert behavior. We're not going at one person. This is a Team Truth is for every motherfucker. I just posted about a goddamn Baltimore City police or Baltimore County police that just got 50 years for having sex with his granddaughter. Like, what the fuck wrong with y'all? We don't discriminate. Sick is sick. Sick is sick. And on this, we don't have posts. We don't have a guilty verdict. But we all sitting there and we're going to play our part. Everybody got to sit there, relax, and wait. My daughter got a decision to make, and so do any other of the victims. And they chose to stand up and tell their fucking truth. And that was it. That's it. And that's all. That's why she don't entertain this shit. It's her truth. One thing about it, your king ain't denied. He ain't send no motherfucking thing out there to his fans saying, they all lying. I'm telling y'all, I ain't do this. He ain't saying shit. And he gonna get his chance to face each one of them young ladies and look them in the eyes. And that's when everybody know. All that other shit, I don't get into that, man. I don't get into that. And it just ain't worth it. When I'm telling y'all all the names and all that, I just wanted to get on here to clarify a few things and let it be on. I got some stuff that I'm in the middle of doing, and that's what I want to tend back. But I appreciate everybody coming to the live. I hope that this don't get taken out of place and ran all through the wrong way. And I hope that anybody that need to hear this again, listen clearly to what I said. And not fucking call me and be saying, well, you said this and you made this is why Larry took it this way or Sam took it this way or this. But no, we're not going to play that fucking game. I talked to Larry. Larry feel like is anything you can get right here and call me. But going on fucking live after live and throwing subliminals and acting like you don't know the separation of it and you was a major part of all the shit. It's a problem. And that's where the division came in. And this is why these women are so fucking confused. Nobody tell no motherfucking story about my life but me. I mean, I can't agree with that. I think Larry did a tremendous job on everything that he was doing because his fight was pure and it was from the heart. You know, it's just he got lost. He got lost. I don't want to say in the fight. He got lost in some of the people that was following us, some of the supporters that been supporting us, some of the people that Polder came on as close relatives. I mean, close friends to the Team Truth YouTube brand. That was it. That was it. And that's where I think he got, he got a little lost. And that's what I spoke on. And we'll deal with whatever we got to deal with. It probably won't be on here. We'll deal with it. It's fine. It has nothing to do with y'all. But one thing about it is I just wanted everybody to know is anything that I have to deal with, I deal with off the internet 90% of the time. And then this one just had to be addressed because there's so many missing hit people that support Team Truth and Team Truth LLC that I had to do it this way so to get everybody attention and get everybody to record and screen record, whatever the fuck they need so that they could play back and say, well, Angelo didn't say this. Oh, this is how he said it, because I don't understand how the fuck I've been saying everything clear as I'm talking. And the next thing I know tomorrow, I get a phone call say, yo, you said this about or you said this that way about that person. Like, what the fuck are y'all talking about? I talked directly straight to what I said, and that's what I meant. And that's it. What's up, fam? So, it is what it is, man. Yay, Black. Hit me up later on. So, it just don't make no sense, man. I just feel like, on this shit here, this won't supposed to be nothing equivalent to street shit. But here it is, we on here, and this shit more savage than being in the street right now. Like, this makes no sense to me. You got women that they going nuts. The men playing both sides. Like, I ain't never understood this shit, man. And I'm not gonna bow down and be a part of that shit. Exactly. And the difference is a lot of people, I'm going to say this one more time. A lot of people on this support side of Team Truth have been victims. So I'm telling you, it was an honor for y'all to pick me and allow me to hear y'all truth, man, hear y'all stories. And I never judged. I never did anything. I sat back and I played my part, man, because I want people to survive. I want people to do good. I want people to do great. I don't count people money. I don't count people money. I don't bash people for getting money. I want everybody to do great. I was blessed a long time in my life, so getting it is easy. It's not that hard, man. I'm people, we kings, man. We gotta be breadwinners. We have to go out and get it, man. But our queens right now is stepping up. They breadwinners. But that don't mean we sit there and sit beside them. We help them and they help us. We get back right. Like, yo, we got to get balanced, bro. And this YouTube shit is crazy. This could be a powerful message, but instead it's back and forth with bullshit. That's the crazy shit I don't understand. So on that note, I'm overexert myself because I said I wasn't going to be on here this long. And I don't want y'all to take this the wrong way about what me and Larry got going on. Is between me and Larry. Not me, Larry, and Sam. Not me, Larry, and Alicia. Not none of that shit. What me and him got going on is me and him. Me and him got to deal with this because he know what I'm feeling and how I'm feeling. And now he understand why I feel like I feel. So he has to straighten this or not straighten. But I don't need YouTube to feel like, oh, they not together, this and that. We're always together. If I call, he's going to pick up the phone. If he called me, I'm going to pick up the phone. So it is what it is. It's internal. And we either do some internal fixing or we leave it be. That's it. That's it. So I thank all y'all for always coming out supporting. I got major love for y'all at all times. You know, it never been nothing but love. I appreciate everybody that understand the difference why Team Truth had to be more come out of the background and kind of give everybody an understanding of the difference, because that's real life changing stories over there, man. Over there is real life drama, man, and trauma to people, man. And I couldn't even begin to tell people the type of trauma stories that I've heard and witnessed and seen, and people show me in black and white all their truth, man. It's sick, man. It's sick. So if y'all got energy to fight and always be negative and want the mess and all that, won't y'all do research and help some of these women find different things in their life, man, and comfort zones in their life that they can start rebuilding their life. Try doing that instead of adding confusion and fighting and fire to motherfuckers you don't even know on the internet off assumptions, bad assumptions. Because all y'all did was saying some shit about this young girl, Nova. I don't know what y'all went through before me, but I'm talking about when around me and Peggy and all this, y'all goddamn lie. Y'all ain't do nothing but spread lies around the internet and through Chain Truth, period. Fucking lies. And for Sam, please, whoever was in that Zoom, text Sam and let her know she was a liar for calling me up trying to say that I said that. Fucking liar. Period. So on that note, peace. Y'all have a great night. Enjoy y'all weekend. I want everybody to know, man, to be safe. Pay attention to this news. Pay attention to real news about what's going on with these situations, because I'm telling you, I don't think 2021 will be as nice as we think. I think that we on a break of a bad race war within the United States. And when I say race war, not just black and white, because we got a lot of white people now, white brothers and sisters that have understood the history and have sided with us. So we got a war coming, man. A race war is this what it's called. But man, we got to be prepared. We got to be paying attention to the real shit out here, man. Anybody that's interracial, guess what? Y'all considered black. Simple as that. There's no in between. You know, so that's what we got to be more focused on. This shit here gonna happen. It's got a date. So we're gonna see this. But this war that's going on right beyond in front of us, this shit don't have a date and it don't have a warning. So I'm telling y'all, man, y'all better stop paying attention to this fucking YouTube shit all day, and y'all better start paying attention to how to get your fucking gun license, how to fucking protect your house, start learning how to have escape routes if some shit happen, all types of shit. That's what I'm telling y'all. Protect yourself. And on that note, Team Truth LLC, major love to everybody on the internet, and you know, enemies and all, you know, because I fear nobody but Allah. And on that note, man, I pray that everybody find their inner peace and start focusing on their own family and take some time off this shit to just relax. Take some time off this shit to get away from this shit. Leave your phone. Delete that shit for a week. That way it ain't even on your phone. You can't even get notifications, at least for a week. Take a week off for yourself. And you're going to see some of the shit that you may think you don't neglect. you see how much you did neglect. We all did it. We all victims of it. And that's all I'm saying. On that peace. Major love, and may y'all be safe. Peace.
Okay. Now, do I remember the beginning of that video for the timeline? I don't. I'm going to. I really need to go back to my email and see what did y'all want me to do. Hold on. Child. Child, these are bullies around here, honey. They call the cops. Yeah, I got that. Um, let me see. Check my traps before I get out. See if anything else done came about. Damn, I can't see. Colors. One, two, three, four. Nothing puffing. Nothing for our curler. Our curler. So with that being said, honey, I'm doing 5 hours. I'm finna push out. Mm-mm-mm. All right, y'all. Ain't nothing really shaking. Ain't nothing really shaking around here. Ain't nothing really shaking around here. I'm gonna listen to a few tunes going out the door. Check some. Mm-mm-mm-mm. Y'all let me see if we got any more legal updates. Let me see if I can find any legal updates. Any analysts. Let's see. Mm-mm-mm-mm-mm. Damn, I can't see. I don't know why they still got this running right now. Oh, hold on, let me see if there's something you want to watch. Okay. I see a panel of some analysts. Y'all want to take a peek? Want to listen?
Hey there, everybody, I'm Jesse Weber, and welcome back to Law and Crime's continued live coverage of the Sean Combs criminal case at a federal court in New York. Today is a very important day. Why? Jury's not there. You might be saying, why is it an important day? Why? Because at 2 p.m., we thought it was going to be 12. They pushed it back to 2 p.m. The court is going to go live with the attorneys and the judge to go over jury instructions in this case. So important in a complicated racketeering conspiracy, sex trafficking, transportation to engage in prostitution case. The law matters. The elements matter. This is going to be the roadmap that the jury is going to use in their deliberations. This is the law that will guide them. And it's a complicated case. So how both sides tweak the language, what they cut out, what they're telling the jury they're telling the jury they need to find in order to find Sean Combs guilty is so important. Now, closing arguments will happen tomorrow. We think it's actually going to extend into Friday. This jury might not even be handed the case until Monday. And by the way, it might take them some time to actually go through the jury instructions. Now, if you want to talk about one word that defines this morning so far in this case, confusion. There is confusion. Why? So first of all, I've seen a lot of chatter about this. We're going to be taking your questions about this whole case, including this issue as well. So this is our lunchtime show. If you have any questions for the next hour, submit them. We'll answer them. But what happened? The court submitted a letter last night, and I'm going to read you a portion of this letter. Now, in the racketeering, by the way, racketeering conspiracy, the prosecution is not only alleging that Sean Combs operated a criminal enterprise, that there was a criminal agreement between him and others to facilitate crimes and cover them up, and that portion of the charge, but that they have to prove at least two underlying crimes. There is racketeering, there is forced labor, there's kidnapping, there's arson, there's bribery, there's sex trafficking, there's drug offenses. Well, what happened? The government submitted a letter, and it says this: in an effort, by the way, to streamline the jury instructions, make them more easily digestible. They say specifically, the government has removed instructions from the charge relating to attempted kidnapping under both California and New York law, attempted arson under California law, and aiding and abetting sex trafficking. Now, there's been a lot of chatter today and a lot of reporting that, oh my gosh, the prosecutors are completely throwing out kidnapping and arson, which were big factors in this case. A lot of evidence came forward about that with Capricorn Clark, Kid Cudi. I don't think that's accurate. Why? I'm going back to the latest indictment in this case. And under the racketeering charge, when they talk about all of the predicate crimes, they talk about this. I'm going to read it verbatim. Multiple acts involving kidnapping, and then it says it's chargeable under the following provisions of state law. California law, kidnapping. California law, attempted kidnapping. California law, aiding and abetting kidnapping. California law, conspiracy with kidnapping. There's New York law, kidnapping. New York law, attempted kidnapping, aiding and abetting, and so forth. My take is, yeah, they might be getting rid of the aiding and abetting with respect to California law and New York law. They might be getting rid of attempted arson under California law, aiding and abetting of sex trafficking. But you still have the kidnapping. You still have conspiracy of kidnapping. You still have aiding and abetting with kidnapping. So, and the same thing goes with arson. So I don't think they're throwing out all of these charges, but I want to talk about it. I want to bring on right now Law and Crime's in-court reporter, Elizabeth Milner, who's going to be in court later today when hopefully they clarify this a little bit up. Elizabeth, you and I were talking about this. If you have any guidance about what you think is going on here, but also to provide more context, doesn't it seem unlikely that the prosecutors would abandon outright all of arson and all of kidnapping, considering what was presented to this jury?
Yeah, it seems like a really kind of surprising announcement that they made in this particular letter, especially given the amount of evidence that we heard, especially when it was coming to, or when it had to relate to Capricorn Clark, or even instances of Cassie being locked in these hotel rooms, or when it comes to going back to Capricorn Clark, the whole lie detector aspect, and her having to go inside that, I guess, abandoned building right when they were kind of switching offices in order to be having to do these lie detector tests over and over and over again after multiple days. And I thought that was probably maybe the strongest piece of evidence the government had in relation to those. So it was really surprising that that decision came down. But it doesn't mean, again,
to your point, Jesse, that they're abandoning everything. It doesn't mean that charges are dropped. I think a lot of people are kind of miscommunicating that they think that, oh, Diddy's about to walk free today. It's none of that. And so it was a pretty surprising decision by the government. Maybe they were persuaded a little bit by Alexandra Shapiro's argument yesterday when they were moving for that motion for the judgment of acquittal. But in the end of the day, we'll kind of get more clarity once the charge conference begins. I was a little disappointed it's now starting at 2 p.m. today. I was hoping it would start at noon, but it's great because now I get to see all of you guys, hang out with you guys for a little bit. But yeah, we should get more clarity hopefully at 2 o'clock when court starts today.
And let me say, you weren't able to come on the show yesterday because of the scheduling. You had like 5 minutes to get back into court. We have a lot of great responses for you, Elizabeth. And by the way, if anybody has comments or questions for Elizabeth, she's in that courtroom every day. Shoot them over. We'll make sure to answer them. Real quick, I have an expert panel, but I have with me right now litigator Rich Schoenstein. If I could bring him on real quick. Yeah, I got him. Rich, good to see you. Am I right? They're not abandoning arson and kidnapping. And
I believe you're right. And this is why I'm looking at the draft verdict sheet that your great producers printed out for me. And it says basically the first question is, do you find defendant Sean Combs guilty of racketeering? And then it asks a question about whether every single predicate theory has been proven or not proven. So it goes over kidnapping under California law, kidnapping under New York law, arson under California law, bribery under California law, and so on.
You see that lawyer there pulled out the verdict sheet. We all think alike. Jury instructions, indictment, verdict sheet. Okay? We might not tell you what we be doing, but we think the same thing.
I read this, the prosecution is only conceding attempted kidnapping under California law and attempted kidnapping under New York law and attempted arson under California law. And probably the reason they're doing that is so they don't have to get into what is attempted and not attempted in the jury instructions and in closing arguments. They're just streamlining the case. But it's still very much about kidnapping and arson and all of those other crimes.
So I go back to Elizabeth. I mean, we have questions coming in. Eric Charlotte says, and we've been talking about this, does the streamlining mean the arson and kidnapping are no longer being charged? We're saying the complete opposite. It still seems to be part of the case. But they ask, are we to disregard Kid Cudi's and Capricorn Clark's testimonies?
Doesn't seem like we should disregard that at all because there are still so many kind of layers to that. And sure, yes, in terms of the attempted arson and, the defense really kind of pointing out that there was female DNA that was found on the Molotov cocktail, something that they really wanted to make sure the jury understood that, especially when it also came to the whole fingerprint debacle and just the insinuation that fingerprints might have been destroyed on behalf of allegedly, Sean Combs possibly having something to do with that, which we don't know that to be the case at all. It was something that was, objected to by the defense. And it was something that also is going to be struck from the record. So when the jury goes back to deliberate about all this stuff, all these witnesses and all their testimony, they're not going to see that portion of the record or anything like that. But in terms of just disregarding Capricorn Clark's testimony, there's still so many layers to that in terms of possibly forced labor, possibly just her experience working with Sean Combs and just what she had all witnessed with Cassie, and also how Capricorn Clark's testimony may help verify Cassie's claims, all those types of things. And in regards to Kid Cudi, I don't think we should disregard his testimony either, especially when it comes to, allegations of the threats that maybe he had heard from Cassie in terms of just sexually explicit videos being released, all of that sort. So I don't think we should rush to judgment as far as dismissing their very important testimony altogether. I think, when people see a letter that says, oh, the prosecution's dropping this, I think they were like, oh my God, that means it's over. Right. That means it's a sure win for the defense. But, there's still so many layers to it that I think that we should hold off on rushing to judgment just yet until we really know during this charge conference today.
And we're going to talk more about that. Elizabeth, while I have you, what can we expect from this charge conference today? I mean, again, I'm looking at this letter, the government's response to proposed jury instructions. It's really interesting because they talk about what the instructions should be for sex trafficking and forced labor. They talk about, for example, earlier consent from a victim does not mean, is not determinative of whether or not a victim was sex trafficked. They talk about how payment is not determinative, that the court instruct the jury that sex trafficking, labor, and payment to the victim for that conduct are not mutually exclusive. They talk about cumulative conduct. What are you expecting today regarding this charge conference? Because I will say, I think it's quite important in any case, but quite important in this kind of case.
I definitely think today is an important day because we'll really kind of see how they're going to map out the instructions that'll be given to the jury once they eventually deliberate. And it's very important. This is a pretty complicated case. So I think the government putting in their proposed instructions in terms of, just because maybe an alleged victim had agreed initially to doing the hotel nights or the freak offs, that just because they initially may have agreed to do it doesn't mean towards the end that they still weren't apprehensive. They still wanted to say no. They still conveyed that they said no. And I think that's where they have to really kind of lay out very clearly, especially possibly in layman's terms, just how murky the waters can get in terms of whether or not that maybe maybe the jurors are talking, or maybe the jurors are thinking that possibly because, both Jane and Cassie were in relationships with the defendant, that maybe that kind of muddies the water in terms of, can somebody who was in a relationship with the defendant be a victim of sex trafficking? I think the government has to really kind of lay that out in their proposed instructions. I think in terms of the defense also, I think they're going to want to make sure that the jury also knows very clearly what each predicate act under RICO is. It seems like, from the most part, from my understanding of being inside the courtroom, I think they might be a little more concerned with count one, especially just all the underlying things that go with count one, again, that being racketeering, conspiracy, and just kind of, again, laying it out very simply for the jury. Because even sometimes when I'm in the courtroom, I'm kind of like, okay, what did I just hear? What is this interpreted? And I'm just, I'm not a lawyer or anything like that. So, imagine me being on a jury. I would want things just really spelled out very clearly. So I think both sides are going to take their time making sure that they get everything that they want in on these proposed jury instructions. But I also think an interesting thing, Jesse, is I'm kind of interested to see if the prosecutors and the defense attorney who are going to be giving the closing arguments are going to be inside the courtroom today for this charge conference. Because yesterday the judge said that, he is okay with the whichever lawyer is going to be giving the closing argument not to attend the charge conference, and the other lawyers can kind of argue everything out. But I'll be interested to see if possibly, Maureen Comey will be in there, if Mark Agnifilo will be in there, who I presume is going to be giving the closing arguments in this trial. But we'll see if they'll show up now that court has been pushed back a couple of hours today to begin at 2.
Right, because they need to prepare. They need to prepare for closing arguments, which are quite important and quite lengthy in this case. Before I let you go, Elizabeth, what's the vibe like we've seen this past week? What was the vibe of Diddy? What's the vibe of the jury? What can you tell us? How do they look? How do they, what's their demeanor like as we're coming to the conclusion of this case?
Yeah, well, as far as the jury is concerned, I kind of feel like maybe they were kind of tired of possibly reading all those text messages, watching all those sexually explicit videos, because that is what it felt like for most of the duration of this week, even going back to late last week. And so, I think maybe for the jurors, they're probably a little at the tired point of this trial. It's been almost 2 months at this point. And so I think they're kind of like, okay, there's a light at the end of the tunnel. Eventually we'll get this case. Eventually we'll deliberate. But again, I'm just guessing. I'm not inside their heads or anything like that. But as far as Sean Combs is concerned, I will say this. I think that in terms of just his defense attorneys and their arguments, and I think that he seems pretty proud of what the defense put up, even though we weren't expecting a very long case from the defense's case in chief. Really, it was just them reading stuff into evidence, reading exhibits, and reading a bunch of stipulations. But it seems like, from what I could tell of just his demeanor and vibe inside the courtroom, he seemed pretty pleased with what his defense gave, especially during those cross-examinations of the many witnesses, including Don Richard, including of Mia, including of Jane, including of all the special agents, just all the various witnesses that took the stand on behalf of the government, and even in terms of just the assistants and their testimony too. So I think as far as just the end of the trial, we're getting to the beginning of the end here. I think, we'll see kind of what happens with closing arguments tomorrow, but it seems like, possibly maybe Sean Combs is feeling pretty good right now. He said the judge was doing a good job, an excellent job. He added yesterday, and it actually got a chuckle from the judge too. And so I think as far as the vibe goes yesterday, he seems pretty upbeat, given that, on the tail end of this, it's possibly that, the jury will come with a decision. And I can only imagine the weight and how that might possibly feel on a defendant, especially as high profile as Sean Combs.
You mentioned concern. We put up a poll. Are you concerned about the charges dropped last minute influencing the jury's perception? 46% say very concerned. 34% say not at all. 19% say somewhat concerned. Interesting. I don't know if the jury even knows granularly what was dropped or not. They don't know about this, but they will be presented jury instructions, and maybe, I don't recall during opening statements if they were that specific, saying aiding and abetting kidnapping, conspiracy kidnapping, attempted I think they just mentioned kidnapping. I don't know if the jury really is going to know so much about this. But Elizabeth Milner, thank you so much. You and I are going to get together for our recap episode later on today on Sidebar. We'll figure out what the jury instructions are, what the charge conference was like. Thank you so much, and get out of the heat. Get inside that courtroom. Thank you so much, Elizabeth. Appreciate it.
Thanks, Jesse.
Oh, and I forgot to mention, Nene says, thank you, Elizabeth, for explaining this letter. Okay, so now I want to get back to my panel. Not only do we have with us Rich Schoenstein, but I'm also joined by former prosecutor Barrett Berger and criminal defense attorney, former prosecutor Safa Robinson Ferrer. It's great to have you both here. Barrett, I want your thoughts on this because there was a question that came in from Old Hollywood Angels. Isn't it sloppy to drop charges? The jury will think it's sketchy. So I guess there's a couple of things here. You think the jury even is going to know that there's this tweak to this? Assuming I'm correct, assuming we're correct, that they're not dropping arson or kidnapping in totality, if they're making these slight tweaks, is it sloppy, or does it say something about how the prosecution feels about their case?
Yeah, so good question. Not sloppy at all. This happens all the time in RICO cases. I prosecuted a number of RICO cases, and at the end of it, you sort of clean up at the end. Now, I want to just be careful about one thing. They're not dropping charges here. And if you look at the government's letter, they explain it. They say, we aren't proceeding on these theories of liability.
Right.
Again, a lot of legal jargon here, but all that means is for racketeering, the government only has to show 2 predicate acts. That's all they have to show. They've alleged far more than 2. And to some extent, they don't need to bite off any more than just 2. They'll still have more than 2, but they're just simplifying it. They're saying, Judge, we're not saying that he aided and abetted sex trafficking. That's not our theory of liability anymore. For racketeering, we still may proceed on the arson, but maybe not on the attempted. So they're just making it a little cleaner for the jury. And I think we want to push back against this idea that they're dropping charges. To your other question, will the jury think that's sloppy? Absolutely not. I don't think the jury is going to have any idea what predicates were alleged in the original indictment, what things are going to go forward. When they get their verdict sheet, it is not going to show like a big red X on the things that were taken out. It's only going to have, what they actually have to decide before them now. So I don't think the jury is going to think this is going to look sloppy. I cannot imagine this will influence their decision. The only thing it's going to do is shorten those jury instructions by a little bit, which if the jury was smart, they would thank the government for that.
It's a good point. Great analysis, because Safa, we just got this question. By the way, all-star panel. Look at this all-star panel we have here. But Safa, we got this question from Nestdog. Am I right to believe that the feds just made the case easier to follow?
Absolutely. It makes it easier. And to my other counsel's point, is it really just streamlines the case for the jury, especially once it comes time for the jury to be charged by the judge. It simplifies everything. So now the judge isn't going to have to explain what attempted means or anything of that nature. And I don't think that the government was really, and as the evidence has been presented at trial, I think their theory was that he actually did commit arson, that he didn't attempt to, but that he had done that, or that he attempted to kidnap Capricorn Clark, but that he actually kidnapped Capricorn Clark. So it essentially streamlines it, makes it easier and more digestible for the jury before they go back to deliberate.
Rich, Nina C., if something is dropped, it helps only the prosecution, as it removes reasonable doubt for certain predicate crimes for RICO.
Yeah, again, I agree with the other panelists. They're not really dropping any of the predicates.
Yeah.
They're dropping a sub-theory or 2 of some of the predicates just to streamline it a little bit. As far as I can tell, kidnapping is still in this case, arson is still in the case, bribery is still in the case, witness tampering, forced labor, sex trafficking, all of the predicate acts are still in the case, still on the verdict sheet. We're just talking about minor tweaks to the jury instructions, which are going to be several hours long, no matter what happens.
So Kayla Williams says, I love you guys, best and reliable. I love how non-biased you all are. Thank you so much. We really, really appreciate that. We're always trying to be. Okay, so here's something interesting, Barrett, that we got a question coming in. Where is it? I'll just go to this one. This is from Matthew Robillard. Would it be fair to say that tomorrow's closing arguments could be the turning point in this trial? It really feels like this could make or break it for both sides. Am I exaggerating by thinking that?
You're not exaggerating by thinking that at all. Closing arguments, I agree. I think they are the most important part of the trial. This is a chance for the government to bring together all of these various pieces of evidence that they put forward over the last few weeks and try to make sense of them for the jury. They also want to connect the different pieces. Now, you remember through this trial, evidence came in, it didn't always come in consecutively. It's not like they started, okay, let's start 10 years ago and just go in order. They heard different things from different witnesses. This is the government's chance to tie it all together. And really for them, the important part is to show not only how it connects together, but how witness A's testimony really supports witnesses B's. And the text messages from this person actually impact what you heard from them. So it's to bring all these little pieces together. For the defense, this is an amazing opportunity to do the only thing that they have to do, which is to poke holes. That's why they didn't call any witnesses. Their whole goal is just poke holes. And if you can find enough little holes, it's going to make the whole boat leaky, and you're going to get, at least a hung jury if they can do that effectively.
We have a question here for you, Safa, from Nancy Nicole D. If Jesse is correct and the Mann Act charges stick, which, by the way, we're not talking about the Mann Act. We were referring to racketeering conspiracy. But let's just say when we talk about Mann Act, the transportation to engage in prostitution charges, which I've said before multiple times, I think is the easiest path to conviction. I would even go on record saying I think there's a 95% chance they will convict him on that. The travel records, the payments, the text messages, the testimony, all linking him up to essentially transporting sex workers and Jane and Cassie for the purposes of sex work. I think it's there. But anyway, Nancy Nicole D says, if Jesse is correct and the Mann Act charges stick, based on your experience, what kind of sentences do judges give for this type of case? Albeit this is not a typical case. So yeah, we've always talked about how racketeering, Safa, can carry up to life in prison, sex trafficking, a minimum of 15 years in prison. For the Mann Act charges, for the transportation to engage in prostitution charges, what realistically could he be looking at?
I think it's going to depend on what the jury is ultimately going to convict him on first and foremost. If he's acquitted of the RICO and if he's acquitted of the I don't think he's going to be acquitted of the transportation to engage in prostitution charges. And there's a toss-up on the sex trafficking charges. I believe, if I'm not mistaken, his minimum is 5 years or 15 to life. The judge is going to ultimately take all of those things into consideration. In federal court, there are sentencing guidelines that the court will look at. They're going to do a pre-sentence investigation to determine, where he's going to fall on the sentencing scale. They're going to categorize him in all of those sorts of things. And not only that, but once it comes time for sentencing, of course, his attorneys are going to argue for the most lenient sentence. So it's going to depend, I think, on what he's ultimately convicted of and how much deference the judge is going to give as to what charges he was convicted of in terms of what his full sentence would be.
Barrett, let me just throw this to you as a former prosecutor. For those charges, I believe they carry up to 10 years in prison. I've had back and forth about it. There are those who say he will get 10 years if he's convicted of it. There's those who say he will get nowhere near 10 years. Where do you stand on that if he's convicted just of those charges alone?
So let's say he's, in your hypothetical, if he's just convicted of the Mann Act charges, acquitted of everything else, I think he will not get nothing. And here's the reason why. The judge has sat through this entire trial. The judge can bring in other information that he knows about the defendant when sentencing him. So he's not just sentencing him, even though that's the charge he was convicted of, is the transportation of the sex workers. He can bring in things that he learned about his treatment of women, about his potential arson, the kidnapping. All of this information he's learned about can be relevant conduct for purposes of sentencing. So I think there is absolutely a very high likelihood that even if those are the only two counts he gets convicted of, that he would serve close to the maximum for that.
Okay, so we shall see. We have a question here for you, Rich. This is from Daniela, 3984. What happens if the jury can't decide?
Well, then it's a hung jury. And, we've seen this. Sometimes the jury could decide on one or two counts, but not all of them. There are 4 counts in here. There's racketeering, there's the sex trafficking count, and there's transportation with intent to commit prostitution. There's actually 5 counts because there's sex trafficking for Cassie and sex trafficking for Jane. There's transportation with intent to commit prostitution for Cassie and also for Jane. I agree with you. I think those 2 transportation for prostitution counts are sort of layups. But if they can't reach a verdict, if they can't reach a unanimous decision, then it's declared a hung jury, and it's up to the prosecution to decide if they want to try it again.
Yeah, Isabella Pinho says, could the prosecution be concerned about a potential hung jury? Of course. I mean, there's always a concern about that. Okay, Barrett, let me just go back to you. This is from Terry Damon. Can anyone answer me? Will the feds be able to seize his assets if they're in his mom's name?
Yes. So asset forfeiture will be involved. If he's convicted, there will be pretty rigorous asset forfeiture proceedings and restitution proceedings to figure out how to distribute those assets. The complexity here is that there's also civil litigation. So that will probably need to play out as well. But the fact that you put something in somebody else's name really is not a bar when it comes to asset forfeiture. The feds still can go in, they can seize things. They will be able to do what is right for the victims here.
Safa, over to you. This is from Lily Lou. Jesse, how are the prosecutors still credible after dropping charges? We were talking about it's not really dropping charges, but after dropping, let's just say theories, and showing text out of context just to fit their narrative. It seems to me, Safa, what this is hitting upon are the summary witnesses and the charts that were presented, because the defense has said in their cross-examination of these prosecution summary witnesses, these charts were incomplete. They didn't include every single text message that might have provided more context, particularly with Cassie or Jane. But I throw it to you. How are prosecutors still credible after this?
When prosecutors prosecute cases, they always have to act with ethics, first and foremost. So I don't think that they're uncredible. I think, again, that they are going to put on their case in chief, and they have put on their case in chief. Their case in chief is going to fit the narrative in theory that they want it to fit, and what they want the jury to believe in order to make a finding of guilt beyond a reasonable doubt. Now, from the defense aspect, of course, we want these extra text messages because it completes the narrative of the conversation. And I think the defense did a good job of highlighting that. As a former prosecutor, and even now as a defense attorney, I've always thought and learned that, you always want to get ahead of things as they prepare or come out during the testimony of your witnesses. You don't want the jury to find something out from the other side that you could have easily brought up and explained away from in front of the jury before the other side got to bring it up, because then jurors might not be so trusting of the prosecution or whatever attorney or whatever side has brought in this information. So it's really important for that to happen, for them to get ahead of these things. And so I don't think that they're uncredible. I think that they're just holding on to their theory. And of course, they're going to put on evidence that fits their theory or narrative.
We put up a poll. What's your prediction for the outcome? 45% of people who took the poll say guilty. 24% say split verdict. 21% say not guilty. And 8% say too early to tell. Okay. Got a question for all of my panelists. This is from Legs 7K. Hello, Jesse, Rich, Safa, and Barrett. Great show. Thank you for all the information over the weeks. You're welcome. Thank you so much. Just a quick question. Is there anything the panel would do if they worked on the trial? Start with you, Rich.
Anything I would do if I worked on the trial?
Yeah.
Do I get to pick a side?
You can. This is the lunchtime show. There are no rules on the lunchtime show.
I don't know. Listen, I think this case, from what I can tell, and we're in New York, we're in federal court, so we don't get to actually see any of this go down on camera, which is terrible. So it's a little harder to evaluate. But from what I've seen, I think the prosecution has put on a very difficult case pretty well, pretty efficiently, especially compared to some RICO trials we've seen recently. They've gotten in the evidence they need to get this case to the jury. And I think the defense is doing a good job because they picked a theory of the case, they stuck to it, they didn't put their client on the stand, which I wouldn't have done in a million years, and I think they're right about that. And they're going to take a swing at this in closing argument. And I agree with Barrett. It is an important closing argument because of that.
Safa, what would you do?
Well, I definitely give credit to what we've learned from what our colleagues are doing in that courtroom, and is to essentially hone in on the fact that the government has failed to meet its burden of proof beyond a reasonable doubt. And I think that that is what the defense is going to hang their hat on. If I was one of the defense attorneys as a part of that case, that would certainly be my argument, especially with regard to the RICO charges and the failure to establish the conspiracy factor, an enterprising factor with regard to that charge in the indictment. It seems, and I would expect that the defense team is going to move in line with that sort of closing, and they're going to go piece by piece with respect to each element of each offense, and show the jury how the government has failed to meet that burden of proof beyond a reasonable doubt.
Barrett, how about yourself?
So I think both sides have actually done an excellent job, as everyone said. I'll say one thing that I probably would focus on if I was a prosecutor doing the closing, which is something that's a little different than you normally would bring up in a case. I think the prosecutors have to do something to explain to the jury why this case was not overcharged. Because if this is something that we're all talking about, it's possible that the jurors are thinking and talking about it as well. So they need to convince them not only that the case has actually satisfied each of the legal elements, which, as from my seat as I sit here today, it seems to me that they've met those elements, but they really need to convince the jurors why these charges are appropriate and why they actually fit the conduct that they've seen here. So I think it's not as much convincing them, of the legality here, like, did I get everything on the jury sheet? But you really have to convince the jurors why this equates to justice and why these were the right charges for this particular defendant.
Barrett, quick follow-up. Does the prosecution have to explain why they didn't call Christina Quorum, whose name has come up almost every day with almost every witness, the purported chief of staff, the purported main co-conspirator in this racketeering conspiracy case? Should they explain why they didn't call her?
Not only should they not, I don't think they can. I think that would probably go outside the bounds of what they're able to do. I will say the judge is going to give the jurors an instruction saying, it's not for you to consider why, witnesses were called or weren't called. There are strategic decisions, the same way it's not for you to consider, why the prosecution charged the case this way. You have what you have before you, that's all. So if the prosecution was to try to speak on this, I think they would clearly draw an objection, and I think that would probably be a pretty sustainable objection.
Safa, okay, got a question for you. This was a good one. Okay, here we go. This is a question from Irvi. Okay, I'm not sure if this is answered already, but can the jury agree unanimously on a verdict on some charges, but not on other charges, or would that result in a mistrial?
With a unanimous verdict on some of the charges, and they can hang on another charge. So, for example, if they came back guilty on transportation to engage in prostitution, guilty on sex trafficking, but came back, hung or not guilty on the racketeering. If they come back not guilty on the racketeering charge, then that would essentially satisfy the case. He's been acquitted on that charge. The other two he's been found guilty of, and that essentially will adjudicate the case. If they come back hung on the racketeering charge, there's a mistrial with respect to that, and it will be up to the prosecution if they want to go after him again with respect to that charge.
I'm going to throw this one to you because you and I have a sidebar that we're going to record after this about jurors speaking out on the Karen Reed case. The reason I asked that is because we got a question from Daniela 3984. When this trial is over, is the jury allowed to speak out publicly about this case, including who was in the jury and what was said?
Yeah, jurors are free to speak and they're free not to speak. They are out of the court's jurisdiction after the trial, and if they want to engage, they can. My experience is more often than not, the jurors don't want to talk. For example, in the case you mentioned, we've had a few jurors come out publicly and make appearances and answer questions on podcasts or other broadcasts, but most of them haven't. But if they want to, they can. And in this day and age, a lot of people are going to be looking for them once the case is over.
Mm-hmm. And I have a feeling they might want to talk out. you know, you think about that and you think about what their experiences is like, and whether or not this is something they even want to revisit after all of these weeks. And you think about what they've had to see and what they've had to hear. It does become a question, you know, and it's not an easy case to sit on whatsoever. I mean, think about, I talk about it with Elizabeth, how many videos this jury has had to watch. I don't know exactly what was on these videos, but it's not the best thing to watch at 9 in the morning.
We ask a lot of these jurors. I mean, first of all, we ask a lot of time. They've been on this case for 6 weeks, 2 months.
Yeah.
And so they've given so much of their time to the case that it's probably taken a psychological toll. I think we almost ought to offer all these jurors counseling to have to sit through the kind of evidence in this case. And a lot of them are going to want to just get as far away as they can the minute it's over.
Okay, we got a question here from Samuel Gregory. Barrett, I'll throw this to you. Hey, Jesse, at the ending phase, can the feds still offer him a plea deal? Please answer.
Sure, absolutely. He could, I mean, not only do they have to offer him a deal, he could plead to the indictment at any point. I find it highly unlikely. I cannot imagine a scenario they would want to offer him a plea deal, nor that he would take one at this stage. But yeah, the defendant can plead anytime before the jury's verdict comes back.
But what would that look like at this stage after all that evidence was presented?
I mean, again, that's why the government would not offer him any kind of a deal right now that was any different than what was charged in the indictment, right? I mean, that ship has sailed. The offer can't have gotten better for them after they had to go, you know, get all these witnesses, traumatize some of these witnesses by putting them on the stand. You know, I can't imagine that they would offer him any sort of a benefit. But again, every defendant has the right, if they want to plead guilty, he could plead guilty to the indictment at any point. That's, you know, his choice. The only reason that he would ever have to do that is if he thinks that would give him some sort of benefit at the time of sentencing, which, you know, it would give him a minor acceptance of responsibility benefit on the sentencing guidelines. But I think it is, I won't say zero because nothing's zero, but let's put it at a 1% chance of that happening right now.
Safa, this is a good question from Blessing Eek. Not sure if I missed this, but has the judge ruled on the Rule 29 motion? So this happened yesterday, right? At the conclusion of the government's case, the defense basically said, under law, there's nothing for the jury to decide. There's insufficient evidence to sustain a conviction. Even if we take everything that was presented, there's no racketeering conspiracy. There's no sex trafficking by force, fraud, or coercion. There's no transportation to engage in prostitution. And I'll tell you this much before I throw it to you. If it's not denied, I mean, if it's not granted, it definitely gives you a preview of where the defense is going in their closing arguments. And I think they make some really compelling arguments that might not be enough to end this case right now, but potentially raising reasonable doubt. I haven't seen the judge make an official ruling on this. I don't know if you have, but it seems unlikely, right, that the judge is going to grant it.
Right. I haven't seen an official ruling as of yet. However, I would assume that if we've gotten to the point of the charging conference, I think it starts at 2 o'clock, he may rule on it before they begin the charging conference, or either rule on it before they begin the charging conferences. Some judges might reserve, but I don't foresee the judge wanting to spend that much significant time doing the charging conference and all of those things without making that ruling. So I would have assumed that he would have ruled against the defense if he has not already, or that he will rule against the defense. And he's used the evidence in the light most favorable to the government. So it's a prima facie case to establish those elements, viewing the evidence in the light most favorable to the government. I would expect that he would deny that motion and the case would go to the jury.
Barrett, I'll give you the follow-up. We have a question from IMMS Gaming. Just to be clear, is the defense's motion for acquittal denied and still goes to the jury? So, your thoughts on it.
Yeah, so at every criminal trial, the defense will make this motion. It's one of the most standard parts of a trial, and they have to make this motion to really preserve a lot of their rights for purposes of the appeal if he is convicted. The judge probably won't rule on the motion right now. My guess is he may want to write on it after the trial. It is not likely to be a successful motion, particularly given everything that the government has put into evidence during this trial. But this is all pretty routine, both the motion and the judges not ruling on it right away.
Rich, Miss Susan 50 asks, have they chosen a foreperson?
I don't think so. I think in the federal system, the jurors will choose a foreperson. That'll be one of the first things they do when they go back in the room.
I'll give you another question because I'll give you another question. Okay. This is from Matthew Robillard. Regardless of the verdict, can Diddy really come back from this? I don't see how any brand or celebrity would want to be seen with him after all that's come out. And by the way, he's got all the civil lawsuits too.
Yes. Wait, it's funny you mentioned that. As we speak, I have a crack team of interns at my firm assembling the information on all the pending civil lawsuits because I'm very interested in what's going to happen with those when this trial is over. Can he come back from it is really beyond my expertise, right? This is a incredibly famous, incredibly successful, formerly beloved person who built an empire. And whether it can sustain the hits that he's taking now from this trial, I mean, if he gets a not guilty verdict across the board, do I think he could have a second act? Yes, I do.
Okay. Anybody else? Anybody disagree with that? Anybody think that if he's acquitted, he could completely reverse the narrative? Anybody? Nobody wants to. Safa?
I'll take this one. So I think in part it could go both ways. You know, once you get someone who has allegations of domestic violence or sexual abuse or sexually related crimes, it's really difficult to come back from those sorts of things because it's always going to be out there, you know, and there's always somebody that's going to believe the allegations, even if you are found not guilty. But at the same time, I think, you know, American, as we've seen with prior defendants in the country, especially high profile individuals, just because a person may be found guilty of a crime doesn't mean that they can't be vindicated and have a success story in their arena of choice, whether that's in politics, whether that's in music. So, you know, I think it could go either way for him.
Okay. Going back to more questions. Will Law and Crime cover the civil suit trials? Maybe, maybe not. Depends upon if there's cameras, although I don't believe in any of the jurisdictions there would be. But also, I'm not entirely sure. We'll cross that bridge when we get to that. Okay. Hey, Jesse. Okay. Oh, this is interesting. I'll go to Barrett for this one. This is from Fika Kaplan. Hey, Jesse, the American legal system is different than in Germany. Here, the judge decides if a person is guilty or not. Is the judge allowed to say how he would have ruled after the jury's verdict?
Nope. The judge doesn't get to weigh in on that unless it's what's called a bench trial. Some defendants choose to waive their right to have a jury and to have the judge decide their guilt. That's the defendant's choice. But no, in a case where it's a jury trial, the judge won't weigh in on that. The way that you will know how the judge views this case is when it comes time to sentencing. If a judge thinks that a case was, you know, overcharged, that the defendant, you know, not that he was not guilty, but that things, you know, proceeded somehow unfairly for him or that the charges weren't appropriate, you'll see that in perhaps a more lenient sentence, or the judge may, you know, say something from the bench about, you know, I feel like lesser charges could have been brought or something like that. But you won't hear the judge saying, I would have acquitted this defendant or I would have convicted him.
Safa, how much, this is from Samuel Gregory, how much approximately did this trial cost the federal government?
I don't know how much, but a whole lot of money. I guarantee you that. You know, you got the operation of the courthouses, you got the team of the U.S. Attorney's Office, jurors and witnesses and all of these sorts of things. And, you know, the media, the high level of security that's involved in a case like this because of who Mr. Combs is. Don't know how much, but I can expect that it's a pretty penny on the taxpayers.
Barrett, you have a thought on that?
So, you know, some of those are sunk costs because the prosecutors work there. They don't get paid per case. It's not like they had to hire new people just to do this case. A lot of the witnesses were, you know, law enforcement witnesses. The cost to this comes, you know, in two things. One, the prosecutor's time, and you have to say, okay, while they're doing this very long trial, there's other cases they're not working on. There was some travel costs probably of bringing witnesses here, putting them in hotels, things like that. So it definitely costs them money, but at the same point, you know, that shouldn't be a consideration when the government's making charging decisions. We hope that they're charging cases because they actually feel like these are defendants that need to be held accountable and this is the right thing to do. So one would hope that this was, cost is never a factor either to or not to bring charges.
Question from Stella. I'll throw it to you, Rich. Does the jury have a minimum or maximum time they have to deliberate for? And she also added, love you, by the way, Jesse. So sweet. So sweet. I'm sure those are going to be I love you too, Rich.
No. All the loves to you. I understand.
No, it's
that.
okay. I'm sure that you'll get some love.
Well, there's no minimum or maximum time. I will say this, the jury could go and come back in 30 minutes and say guilty on all counts, and the verdict would be taken. There's no maximum time, but the jury can't come back an hour later and say, we're hung. If that happens, the judge is going to make them keep deliberating until the judge is satisfied that there's no way the jury can render a verdict on any of the counts. Now, how long would that be? It's not an hour count. It's not a day count. It's sort of the judge kind of figures it out as he goes.
By the way, follow up to this. I keep saying that the transportation to engage in prostitution charges feel like the easiest path to conviction. The defense kind of raised an argument to it yesterday where they were seeming to suggest he was paying them for their time and experience, right? He wasn't paying them for prostitution, that they weren't necessarily prostitutes. I'm not buying that argument. I don't think it works here. But I also don't know what else they're going to argue in a closing argument about it.
Yeah, I don't think that works. I do think they're in trouble on those counts. By the way, in terms of how long it's going to take, this verdict sheet has 5 counts and it has 18 specific questions that the jurors need to answer unanimously. 18, or tell the jury they're hung on some of them. And that's going to take a long time to go through. I continue to be with you. I think the across state line stuff is the easiest part of the case.
Hey, guess what? Legs 7K says, I love you, Rich. There you go.
Hey, way to go, Legs.
That's good. That's good. By the way, I just got to say something. So I got a comment. We look at the YouTube comments. Somebody said that I look like the main character mouse from Flushed Away. So if we didn't have copyright issues, we would put up the cartoon character. So it's great that you've gotten compliments.
How's your hair doing in the humidity?
Honestly, not great.
Taking it rough.
Not great. Not great. That's this situation for another day. Anyway, let's get back to it. Oh, we got a super chat comment from Jay Davis. Jay Davis, thank you so much. Jesse, you and your team's coverage of this Diddy trial has been second to none. You all lit. Thank you so much. That's so kind of you to say. Okay, let me go to this one for you, Barrett. This is from Madison Thomas. I have a question. So if he's found guilty, will he lose everything that he has, like his houses, his music career, etc.?
So if he's found guilty, there will be forfeiture proceedings and restitution proceedings. And basically those are a way to give back money to his alleged victims from his proceeds. So hard to say, will he lose everything? I don't know, but he will probably have to pay a lot. They have ways of, tracking and figuring out somebody's assets, even if it's not readily available upon first glance. So that would include, things like his businesses, in addition to bank accounts and houses, things like that. So, how those are valued, things like that. These are not easy decisions. Sometimes these legal proceedings, the forfeiture proceedings, are as interesting as the trials, right? Because especially with people with complicated assets, these can be really interesting proceedings. And there's a whole division of the U.S. Attorney's Office that's really focused on asset forfeiture.
By the way, 2 follow-ups to that, Barrett. One, Old Hollywood Angel says, can you say I love Barrett? She's amazing. So you get compliments too. Safa, they're going to be coming in for you as well. Sarah M, though, asks, well, did he have to pay all the court costs if he loses?
No, so defendants don't have to pay for, the judge's time or, the court officers, anything like that. This will be limited to asset forfeiture and restitution, which again, will be significant and tremendous if he is convicted, but he won't have to pay court costs.
Again, I want to go back to something we started the show off, because if you're just joining us and you've been reading the news, you might be confused as to whether or not the government has dropped charges. But again, what happened was, the government filed this letter in anticipation of the charge conference today, in anticipation of the jury instructions being negotiated between both sides and the judge. And the government said specifically, the government has removed instructions from the charge related to attempted kidnapping under both California and New York law, attempted arson under California law, and aiding and abetting sex trafficking. The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. However, as we were talking about, when you go to the indictment and you look at all of the underlying predicate crimes that the prosecution is hoping to prove as part of racketeering conspiracy, and you look at kidnapping and you look at arson, there are specific components of that. So there's kidnapping, the charge of kidnapping under California law. There's the charge of attempted kidnapping under California law. There's the charge of aiding and abetting kidnapping under California law. The same thing is for arson. So Safa, again, you would agree that it seems that the government is not going to be arguing anymore attempted kidnapping under California and New York law or attempted arson under California law, but they still may be pursuing arson and kidnapping under these other theories of liability, because it would be really, really strange for them to drop kidnapping and arson in totality when there's been so much evidence about it, whether it's Capricorn Clark or Cassie or Kid Cudi. Just if you want to put a button on that so our viewers understand.
Yeah, most definitely. And I would agree with everything you just said, Jesse. Not only that, but sometimes it's a decision of strategy. Sometimes when you give jurors too many options, so for example,
we lost Safa. Okay, going to you, Rich. Look at this, we're pulling an audible. What do you think?
Yeah, I don't think, I mean,
Safa, we'll work on getting you back in just 1 second. Sorry, I'm just going to go to Rich real quick, but we're going to work on Safa's audio.
Yeah, I don't think that kidnapping is still in the case. Arson is still in the case. These are sort of subsets of the theory. So if you look at the first kidnapping charge in the verdict sheet, it says, did the crime include kidnapping, attempted kidnapping, aiding and abetting kidnapping, or conspiracy to commit kidnapping? And the prosecution is saying, drop the attempted kidnapping. But by implication, that means we're keeping kidnapping, aiding and abetting, conspiracy to commit kidnapping, all the other kidnapping adjacent allegations.
By the way, I think we have Safa back. Look, I think we talked about it. It's a way to streamline the case for the prosecution. It's a way to make it easily digestible, easily understandable for the jury, because racketeering can be complicated. But you do wonder how the defense is feeling at this point. You know, you circle back to the idea they called no witnesses. They only presented a few exhibits. They did vigorous cross-examination. Tell me I'm wrong here, Safa. You remember when we were reporting how Combs said to the judge yesterday when he chose not to testify, "I'm doing great, Your Honor. I've been waiting to tell you thank you. You're doing an excellent job." It seems eerily similar to when he was accused of nodding at the jurors after a really pivotal moment of cross-examination of a key witness. It makes me feel that Sean Combs is feeling good going into closing arguments and deliberations. Am I totally off by that, Safa?
I don't think you're off by that. I think that at the end of the day, it's important for the defense team to put forward their best arguments. And not only that, but for Diddy to believe in the work of his defense team. This is his life. You know, he can't go into this case, go into closings and go into deliberation feeling defeated. So it seems like he's proud of the defense that his team has put on. I think they've done a great job thus far, considering the evidence and what they had to work with. And he has faith and belief in his defense team. And not only that, but in the justice system. And optics matter at trial as well. So, you know, I think that he's tried to put forward this good character in front of the jury, in front of the judge, in front of the media, because ultimately they're all seeing that. You know, the jury's ultimately going to determine whether he's guilty or not beyond a reasonable doubt. And they're watching him. They're watching his mannerisms, the way he's moving and communicating about in the court. And ultimately, if he is found guilty, the judge is going to decide what his sentence is going to be. So I think that he always wants to ensure that he's putting his best foot forward when dealing with the judge and being in the courtroom.
Barrett, I want to just go to you something about the defense's case. I thought maybe at a minimum, they might call an expert to rebut the testimony of Dr. Dawn Hughes, who I thought was an important witness. If we're trying to understand why alleged victims would behave in ways that are potentially inconsistent with being abused, staying in contact with Sean Combs, praising Sean Combs, encouraging freak-offs, setting up hotel nights, she explained the complicated dynamic. And you wonder what their expert, who it seems they had planned to call, what that expert would have said. To not call that expert and just to rely on cross-examination, rely on the text messages, rely on everything else. Do you think that that was a smart strategy, Barrett?
I mean, I guess we'll find out if it was a smart strategy or not. I mean, I think the reason that they probably didn't call this expert is because they felt they did more with the cross and with the text messages. Now, anytime you call an expert witness, it's a risk, right? I mean, you will probably get a lot of information from that expert that's helpful to your case.
Woo, we got that right too. Just saying.
But if you have skilled cross examiners on the other side, they could get your expert to concede certain points that are actually bad for you. And again, this is a really interesting topic. It's a hard topic to come out and say, you know, anyone who stays with an abuser was not actually victimized. That's a hard position to take. So I think they probably thought they made enough headway with their cross examination, and they're going to really hammer those text messages and the witnesses' testimony, you know, the actual alleged victims, their testimony as well during their closing arguments. And they thought they'd get more from that than from an expert.
I mean, they really reinforced it yesterday. So when they were cross-examining the summary witness and bringing up all the messages that are not included in the charts that are maybe problematic for Jane, when they put in exhibits during the defense's case about these messages from Cassie and Jane where they're excited sexually and they're setting everything up, it makes it a great case. Okay, we have a super chat question from Christina Lester. Christina, thank you so much. Let me go to Rich on this one, okay? Playing R. Kelly's songs now profits his victims rather than going in his pocket. Could the same be possible with Diddy's music?
I'm going to say I suppose so. I sort of have a question about how that whole part of this would play out if he's convicted. I mean, Cassie has already settled her civil claims, right? And she's one of the principal victims of the charges alleged in this trial. Does she get further restitution from the government? I don't know the answer for that. And how do you calculate it? And how do you get it? Is it possible that it extends to royalties? Sure, I think that's in the realm of possibility, but there would be a whole lot of litigation about that topic. I think Barrett said that before. I think she's absolutely right.
By the way, we put up a poll. Which Diddy song title best fits the vibe of the trial? Bad Boys for Life, 46%. Can't Nobody Hold Me Down, 31%. Last night, 22%. All right, I want to get some final thoughts here. Safa, I'll go to you. Jury instructions, charge conference today. I think it's really important. I think in a complicated case like this, the law matters. What are you going to be looking out for today as both sides battle it out about the language and the elements and the requirements of these charges?
Yeah, I'm going to be looking for that consent piece that the government is going to try to get in, which just basically says just because a person or a victim may have consented in one instance doesn't mean that they've consented in all instances, or just because there's an intimate relationship between the two individuals that automatically means that someone consents. Also, the instructions with respect to the racketeering and enterprise component, was Bad Boy Records, a front for the purpose of engaging in this criminal conduct and criminal activity. So I think that we'll see a fine tuning of how that instruction is going to be worded and read to the jury. Any possible missing witness instructions and negative inferences, we'll certainly see instructions with regard to Mr. Combs' right not to testify and his right to remain silent, and that the jury cannot infer anything negative from that, and fully explaining to the jury each and every element of the offense and how the government has to prove all of those offenses beyond a reasonable doubt, not beyond all total doubt. So they don't have to, it's not a 100%. Very few things, in the world are with absolute certainty. So it's not beyond all doubt, but beyond reasonable doubt, and a full and satisfactory explanation to that the jury will be able to understand and digest so they can go into their deliberations.
By the way, I want to let everybody know a couple of things. So closing arguments, they're expected to begin tomorrow, Thursday. They're agreed to hold court from 9 a.m. to 5 p.m., so both Thursday and Friday for the closings. with prosecutor Maureen Comey said she doesn't think the jury will even begin deliberating until Monday. So it's a little bit of a timeline. And by the way, here at Law and Crime, for the next 2 days, actually, for the next 2 days of closing arguments and for Verdict Watch, we're going to be doing full coverage all day. In fact, tomorrow we're starting 9 a.m. with Chris Stewart. Great guy, fan favorite. So he's going to start it off. We're going to do full coverage, take your questions all day on it as we cover the closing arguments. Again, before we wrap things up, I want to ask Barrett, closing arguments, what are you looking out for?
Closing arguments, looking out for a couple things. From the government, I want to see a really easy to understand explanation of RICO. I think they need to explain to the jury why this is actually a RICO, why this is an enterprise, and how it can be an enterprise with only him charged. That's what I want to see for them. Something to answer these questions that you know the jurors have in their minds. I'm really interested to hear from Elizabeth how the jurors are actually paying attention. I have had closing arguments where jurors are hanging on my every word, and then I've had closing arguments where I feel like people are nodding off. And maybe it's me, maybe I wasn't being my most entertaining self, but you can tell a lot about what a jury's thinking by how closely they're paying attention.
And Rich, I'll give you the final point. If you want to talk about closings, or I'll give you this question: how long do you think the jury's going to deliberate for?
I think its deliberations will probably take a couple days, but this is what I'm watching for and what I would say about closing arguments. And it's a little bit off the substance and in the practicalities. It is 100 degrees this week in New York City. Yep. These jurors have been sitting in that courtroom for 2 months, watching just brutal, hard to watch video and hearing really hard to hear testimony. They want to be done. If I was doing a closing argument in this case, I would be doing everything I could to trim it down. 4 hours plus 4 hours plus jury instructions. That is information overload. And I know these are thick, difficult charges, but anything those lawyers can do to get through it more quickly for the benefit of the jury is going to inure to their benefit.
There you go. Barrett Berger, Safa Robinson Ferrer, Rich Schoenstein, thank you all so much for coming on, your expert analysis. Really appreciate all of you. Thank you so much for taking the time. Everyone out there, thank you again for your tremendous questions. We're going to, again, do full coverage tomorrow. We're going to do full coverage Friday all day next week until we have a verdict, post-verdict. But before I let you go, if you're interested in more about what's been happening in the Diddy trial, including what's been happening every day, the second season of Law and Crime's hit podcast, The Rise and Fall of Diddy, I host it. It is back. It's exclusively on Wondery Plus. So far, 2 episodes have dropped. Third's going to be coming out next week. You can find it right now on Apple Podcasts, Spotify, wherever you get your podcasts. And if you're curious, take a look. Here's the trailer.
We acting bad. We ain't trying to hurt nobody.
For decades, he was untouchable.
I've gone from Harlem to Hollywood.
Sean Diddy Combs built an empire from the ground up. But now, it's all coming undone.
Sean Combs, the mogul as we know it, is over.
I'm Jesse Weber, host of Law and Crime's The Rise and Fall of Diddy, the federal trial, a front row seat to the biggest trial in entertainment history.
Sex trafficking, racketeering, prostitution, allegations by federal prosecutors that span decades, and witnesses who are finally speaking out.
This is at least the 10th lawsuit filed against Combs.
Each week we break down the courtroom drama as it happens.
How far will he fall, or will he walk free, but with a reputation in ruins? You can listen to The Rise and Fall of Diddy, the federal trial, exclusively on Wondery Plus.
Okay, people. Okay. I done held y'all hostage long enough. Alright, I gotta go. Is it 9 something? Is it, I can't see. It was 8 something. I can't see. I can't see close up. I can see far away. Like that. Like that. So anyway, hey. There won't be no part 2 tonight. What you say? Oh. And change my line. To be real, it got to be real. Ooh, your love. So they pretty much reinforced everything we were saying. Mm-hmm. And I'm finna go, because you know I'm finna go find, let me see if I can find some more about my little family that, the dude, the dude and the girl with the herpes and the witchcraft and all of that shit on that wall, child. It's taking over. That's terrible. I think I'm finna cook some chili. Hot as it is, I'm gonna cook some chili. So anyway, y'all check this out. Hey, make sure you do something good for yourself and someone else. Make it be a good day tomorrow, a better day. And we are out of here at the same time. Bye. See y'all later. Stay up.